4 days off, a long weekend. All right. Good morning, everyone. It's Thursday, July 21st, 2022, and this is the meeting of the California Fair Political Practices Commission. Ms. Linker, would you please call the roll?
Commissioner Baker? Here. Commissioner Wilson?
Aye.
Commissioner Wood?
Here.
Chair Matich?
Aye. Good morning, everyone. Let's begin with item number 1. This is public comment for items not on today's agenda. Do we have any public comment for items not on our agenda? Hearing and seeing none, we'll proceed to item 2. This is our closed session. The Commission will adjourn into closed session to discuss pending litigation. All right, we'll go ahead and reconvene. We've concluded our closed session, which is item number 2, and we have no reportable action from item 2. Now proceed to item number 3, approval of the commission meeting minutes from May 2022. Do we have any commissioner comments or edits to the meeting minutes? And seeing none.
Move to approve.
Motion, do we have a second?
Second.
Second. Any public comment on item 2? Excuse me, item 3. Hearing and seeing none. Ms. Linker?
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
All right, we'll go ahead and proceed then to our consent calendar. That's items 4 through 9 today. Do any commissioners have an item from the consent calendar they would wish to pull for separate consideration?
Chair Matich,
Commissioner Wilson?
I'd like to remove item 6, please.
Any other items?
Items 4 and 5, please.
4 and 5. Commissioner Wood, any items you wish to pull from consent? All right.
No,
The
all
remaining
set.
consent calendar consists of items 7 through 9. Any commissioner questions or comments for Chief Brereton on items 7 through 9? Chief Brereton, anything you wish to inform us about on items 7 through 9?
Good morning. No, thank you.
All right. Public comment on the remaining consent calendar, which consists of items 7 through 9. And seeing none, do I have a motion to approve the consent calendar, items 7 through 9?
Move the adoption of the consent calendar.
I can second.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
All right, we'll go ahead and proceed then to consideration of item 4. This is in the matter of Andrew Doe. Chief Brereton, good morning.
Good morning.
Do you have any opening comments on item 4?
Yes, thank you. So we bring this matter to you with a total penalty of $12,000 for 6 counts. There are 2 types of violations here. The first type is under section 84308, which 84308 is designed to prevent appointed officials from being influenced by or from influencing the making of contributions. So it is a conflict of interest type of statute, but it doesn't involve the typical financial interests under our other rules. It involves campaign contributions. We are recommending $3,000 per count for these violations based on the aggravating and mitigating factors. The aggravating factors here are that Doe was an experienced public official, and the contributions over the limit were not returned. In mitigation, there is no evidence that the violations were deliberate or that there was an intent to conceal. The contributions were timely and fully reported. Doe contends that he did not receive notice from agency staff, and he corrected what he could as soon as he understood the issue at hand. McConnell, who was one of the contributors, did not get the contract awarded to him in the end, and Townsend was the matter that was still pending at the time that Doe learned of these issues, and he requested that the matter be pulled, and it was redone without his participation. Doe has no prior enforcement history. So taking all of those into consideration, and these do not qualify for the Streamline program. 84308 is not included in that program. So taking all of the aggravating and mitigating factors together, we're recommending $3,000 per count for these violations. The other type of violations here are behested payment violations. There are 4 counts, and we are recommending a penalty of $1,500 per count. The timely reporting of behested payments is essential since these types of payments may be made to seek favor with elected officials. These violations on their own, however, would likely qualify for warning letter Streamline Tier 1 or Streamline Tier 2, but because of the 84308 violations, they are included in this mainline stipulation. But because they are lower public harm, that does justify combining the counts instead of charging each Behested payment report separately. We are recommending $1,500 per count based on the aggravating and mitigating factors. In aggravation, again, Doe was an experienced public official, so he should have known the Behested payment rules. In mitigation, these payments, the payment amounts were relatively low. 3 just met the threshold for Behested payment reporting. There was no evidence that the violations were deliberate or that there was an intent to conceal. The Behested payments largely resulted from efforts of Doe's agent, not Doe himself. And he contends that he did not understand that activity of his agent applied to him for purposes of Behested payment reporting. Doe did file some corrective Behested payment reports before enforcement contact, and he has no prior history of Behested payment reporting violations. So taking all of this into consideration, we are recommending a total penalty of $12,000.
Braden, a couple questions for you. First, I notice at the outset that there are actually 2 case numbers associated with this particular matter, one from 2016, one to 2018. Can you explain how come we have 2 case numbers on this one?
Yes. We received the complaints regarding the Behested payment matters in 2016, so that accounts for the 2016 number. We received the complaint regarding the 84308 violations in 2018, which accounts for the 2018 case number. We are bringing these concurrently before you rather than having separate case matters.
Secondly, sticking with the case numbers, so this case originated in 2016. It's 2022 now. I'm curious, why did this particular case, if you can tell us, why did this take 6 years to?
Well, since that's not part of our stipulation, I can generally talk about what types of things can cause delays in our investigations. Sometimes we have difficulty obtaining documents. We have uncooperative entities, we have uncooperative witnesses. People generally aren't happy when we're reaching out to them. So sometimes it's difficult for us to obtain those, to obtain documents. If people are very uncooperative or it's private, personal, or financial information, we will subpoena records. Subpoenaing records takes extra time, and especially if the documents that we requested weren't fully produced with the subpoena, or if there is a challenge to the subpoena, that also takes extra time. We also have, over the past several years, we've had some significant staff turnover and extended absences and vacancies that can cause delays in our investigations as well. And then with the vacancies, when we have new staff, we're training our new staff, so each step of the process takes a little bit longer while we're training new staff to come up to speed. We also have to balance our priorities. We have our older cases that we're trying to work and trying to get through, but new cases are always coming in. So we're not always able to work on a brand new case as soon as it comes in because we have other priorities from other older cases. We do strive to balance this, but sometimes things have to get pushed to the back burner. Sometimes our cases do go to administrative hearings as well, which is, it takes a lot of resources and a lot of staff time, both attorneys, support staff, and investigators, and that will delay work on other cases because that has to take priority at the time. And COVID has been really difficult throughout the process, but even continuing today. It affects our staff, it affects the alleged respondents, it affects opposing counsels and treasurers and vendors, filing officers and other agencies as well. And it has caused delays in contacting people and being able to interview folks, and then also in records production on both sides. So while I can't speak specifically to this matter, we do have a lot of challenges facing us when we are investigating matters, and we try to bring things as timely as we can and as detailed as we can so that we have the facts and circumstances presented to the public.
Appreciate that. I appreciate that you can't speak part of the stipulation.
Chair Madich?
Third question for you. You mentioned earlier that Mr. Doe contended that as to the pay-to-play allegations, that Cal Optima staff, and this is in the STIP, failed to notify him of potential conflict. In the 6 years that we had this case, did we uncover any evidence to support or deny that contention?
So we don't always follow up on every contention that is made in each case because we don't have the resources to do so every time. If we do have solid evidence, typically, that a contention is not to be believed, we typically will include that in the stipulation. Here we included, in this matter, we include contentions as part of settlement as well. And we typically do so in the spirit of negotiations and so that we have both sides of the story. But while I don't have it in the STIP here and can't talk about it specifically, we don't have anything in the stipulation stating that this contention was not found to be valid.
Thank you. Mr. Wilson?
Chief Brereton, thank you for, the summary in terms of some of your back cases and some of the challenges that you and your staff faced over the last several years because of COVID. But I think it would be helpful if you also kind of just gave us a general idea of how many cases you might be working on in a given year, because I know that it's a pretty significant number, and I'm not looking for the specific number, but I think it's important for the public to understand that you and your staff work very long hours to get through the cases, and you're not just handling 3 or 4 cases, in a given 6-month period, for example. So I mean, to the extent, just ballpark how many cases you might handle in a year or a month, I think would give some sense of, the major workload that you're working through.
So we do have in the executive staff report for the Enforcement Division, we give a summary of how many complaints we've received each year and how many cases were opened and then closed. So for example, from 2021, we opened 1,185 cases, and we closed 1,058 cases. Not all of those closures are going to be cases that were opened in that same year. Most of those will probably be cases that had been opened in previous years. So we also are, in conjunction with those numbers, we have a summary of what our older cases are and what that existing caseload is also in our report, to help give you a sense of how many of the cases are moving from the different time frames. And next month we'll have an update from July, so a new quarterly update on those numbers.
Yeah, thank you. I just wanted to highlight the fact that there is a substantive workload that you and your staff are dealing with on a regular basis. So thank you.
You're welcome.
Thank you. I think I'm following up on Chair Madch's question regarding a theme that is repeated multiple times in the STIP on page 7 and on page 15. On page 7, it is according to, I believe, we pronounce it Doe. Typically, Cal Optima directors relied on staff. And there's multiple areas where it's either relied on staff, or I think on page 15, it's actually a mitigating factor, the way it's portrayed, lines 7 and 8, that, it was an agent of the official and not the official himself who, made the request. And you mentioned in response to Chair Madch's question that we want to make sure we have both sides in there. And for me, I'm still wondering, do we independently check these to get our side? Because when I read those two questions, I really did want to know, is that the case? Because it's according to Doe, they rely on staff to point out conflicts. But if we're going to put that in there as their side, what we do to confirm that, it sort of left the question out for me. Because otherwise it could potentially portray in a STIP that's, not that it's acceptable, but that's a relevant fact beyond just that it's their contention, that it's relevant that it might have just been staff or somebody else who did the act for them, when ultimately it is the responsibility of the official to whom the regulations apply, whether they have staff or not, to comply. So it's a little bit of a rehash of the chair's question: what independently do we do, and why do we not have our own sort of statement in a stipulation like this that says we didn't confirm, we were unable to confirm that, or we did confirm it? Because to me, it leaves it hanging out there a bit.
I think it depends on the case, what type of verification we do for a particular matter. Sometimes in this particular instance, we don't have, our evidence didn't give us an indication that there was deliberate conduct or an intent to conceal. And as you previously said, the responsibility is on Doe to understand that he had received contributions in his campaign committee, but he's also appearing as an appointed officer, and so needs to make sure that he's following up on that. And it is ultimately his responsibility. It is somewhat mitigating that staff may have had this responsibility as well within that agency, but those staff members don't have liability under the Act. For this particular violation, it is on Doe's shoulders here. And so while we're considering it as part of the story, because that is something that he wanted to share, it is, and it doesn't contradict some of the other evidence that we have, such as those particular, I do also want to clarify quickly. When you mentioned later that we're talking about the agent, that was referring to the Behested payment violations, not to,
yeah, I understand.
not to the same issue.
Understood.
So so for these violations, we want to make sure that we're including information from the other side. We don't have evidence that shows that these were intentional or deliberate, and the other evidence does support that, in that he took some action right away, saying, no, I missed this, can we please redo this without me being involved? He didn't have the opportunity with the first one, but that is consistent with the other evidence. And so so while we may not have included a specific rebuttal or, comment about his contention, we do have other statements in the stipulation that justify our position that this is a fair resolution of these two violations.
And I appreciate that, and I do understand that the behest is different than the pay-to-play provisions. I guess, not trying to negotiate different language here in this stipulation, but based on what is in here, it does call out to me that if we are going to repeatedly mention that this person said their staff was really responsible for it, that we either address, if we looked into that, maybe even make a statement, there's no contradicting evidence, or really address why it should be a mitigating factor as it is in the in the behest payments area, because I do think that's important. The lesson coming away from this is that it is should be that it's the official, and there's just so much language about how staff didn't tell them. And I would never want this to be a comparable in the future that shows if staff is largely responsible for accepting the behest or otherwise, that it can be a mitigating factor when it maybe isn't appropriate in future cases. Thank you.
Mr. Wood, any questions, comments on this item?
Just nodding vigorously with what Commissioner Baker said, because I also picked up on the staff language and just wanted clarification on that, but I'm satisfied. Thank you so much.
Thank you. Commissioner Wilson, anything further on this item?
I concur with the other commissioners, Commissioner Baker and Commissioner Wood's perspective on this issue.
Right. Burton, anything further?
No, thank you.
All right. Is there any public comment on item 4? Hearing and seeing none, do we have a motion? All right, well, I will...
Out of courtesy, I'll make a motion to adopt the item.
All right, I'll second. Baker?
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
This is the next item. This is item 5 in the matter of Steve Dallas. Burton?
This is a traditional conflicts of interest case as far as count 3 goes. It is based on a gift that was received that was over the gift limit. So we do have violations for acceptance of gifts over the limit, as well as failure to timely report gifts on statements of economic interest. We're recommending a total penalty of $9,500 for this stipulation. The failure to timely report gifts would typically be included in our streamline program. And these violations would likely qualify. Some acceptance of gifts over the limits violations do qualify for our streamline program, but some do not if they are over a certain amount, over the gift limit, or they are a matter that is before the official's agency and there is a conflict of interest involved. Since we both of those, it was before the agency and there was a conflict, then here the gift limit violations do not qualify for streamline. Conflict of interest violations are not included in our streamline program. There were 4 total gifts that were late reported. There were 3 that were over the limit, and then 1 conflict of interest. So taking into consideration our aggravation and mitigation, these are the amounts that we have landed on for these particular violations. In aggravation, Dallas was an experienced official, and he had ethics training. The conflict of interest violations are serious violations, and here they're also related to a gift that was not reported, so there wasn't any disclosure to the public beforehand. In mitigation, however, there's no evidence that there was an intent to conceal. Dallas contends that it was negligent, which is consistent with the evidence that is here, because he was experienced and received training, but he largely corrected the disclosures before enforcement contact. He is also no longer in office. The maximum fine is not warranted for the conflict of interest violation here. The source of the gift was not related to the official, so there was no direct benefit to the official from this particular conflict of interest. The amount involved in the governmental decision was relatively low, and as I said previously, the failure to timely report violations are typically something that would be included in our streamline program, but are included here because of the conflict of interest. So in total, we're recommending a penalty of $9,500.
Brereton. Baker, I think you pulled.
I do, thank you, for the summary. And for me, it's, again, as I sometimes do in these, and it's important, I zero in on something that just sticks out to me. And you've addressed it in your comments, it's on page 8. It has to do with the negligent component. Because there's, the statement at line 15, Dallas contends that this was negligent, but and the reason to back that up, if I'm reading this correctly, is that he's an experienced public official who received training on the very issue that this is referred to. And so that's where I'm having a bit of a disconnect. And it is not uncommon for me to point that out, but what are we using to identify as negligent? And what I think you repeated those points here, but to me, someone who's been trained, who's an experienced public official, that's in the four corners of the stipulation, are you relying on that's negligent and not more along the lines of, don't really want to comply with it. I don't want to give him an intent he may not have had, but I need more to understand how negligence comes from being experienced and taking the training that should tell you what you should do in this case.
Right. So real life circumstances are often not fully captured in ethics training. Sometimes there are circumstances where people misunderstand the training, or they might have a situation that wasn't fully covered in the training, which is okay. We're not expecting training to be perfect, otherwise people would be in training all the time. But at the same time, what we do expect from the training is that sometimes it should remind someone that, oh, I might have an issue here, maybe I should ask somebody else about this. We don't have evidence here that he sought any advice, but at the same time, we don't have evidence that shows that he was trying to hide what he had received. It was more of a situation where there could be a misunderstanding of what the requirements are. And we can be more clear in our stipulations going forward when we have issues like that. But also take into consideration as well, like, these are fluid documents up until the time that we are presenting them to you, because we are negotiating with the other side. So, while we try to be as inclusive as possible, it's also something that the respondent is signing and verifying that this is all accurate. So,
yeah.
Can I, to be fair, Commissioner Chief Brereton, the assertion in the stipulation, as I read it at least, that his contention is that he acted negligently, and he says this is consistent with the evidence. It's true that we point out that he took training, was experienced public official. The other thing you pointed out, though, that I think is really important here is that, and then the SEIs were largely corrected before we contacted him, which to me, that's important, because that tells me that he corrected them on his own volition, if I'm reading this correctly, which is more indicative of, I made a mistake, I was trying to comply, as opposed to, I'm intentionally flouting the rules and I have no intention to comply, because why else would he have corrected? So that's how I understood the last part of that sentence, as supporting our view that this negligence was consistent with the evidence. Is that right, though?
yes, that's correct.
Okay.
And that's why we included that part about, because the timing of when corrective amendments are made is important, because it does help us to kind of weigh whether something was intentional or negligent.
Thank you. And that was exactly the other two areas I was going to narrow in on, because for that reason, thank you, Mr. Chair. Maybe it's how it is written, but it did, to me, I saw it as a whole long point that he's contending he's negligent, and he was very experienced and took the training. And When you mention corrected before enforcement, I just want to understand better what that means. Is it before he found out a complaint had been filed or initiated, or after that, but before really any further contact from the enforcement division?
Just
Because
one
that's
second.
important in that respect.
So definitely before enforcement contact. Let me look at my notes.
Okay.
I can also answer the question about how it played out relative
Thank
to
you.
when the complaint was filed.
Thank you. And take the time you need, because that is something that we say in other contexts, that it's before enforcement was contacted, but I'm not quite sure where that is in the timeline.
I did not write down specific enough notes about the date of the complaint, but it looks, certainly one was before, one may have been before or close in time to.
Okay.
One, just so we're clear, one correction before the filed.
Yes.
Other corrections you're not sure.
Before the complaint was filed or before?
Before the complaint was filed, but all of these were before we reached out.
Okay. Okay, so a complaint could have been filed, but he fixed it before you, the enforcement division. Very helpful. It is language that, you know, for my point, when I see that, again, that jumped out at me as an issue. For future, when you're going through the fluid document, negotiating back and forth, I think that's really important to make even more clear that it's not a mitigating factor and it's not to contradict the sentence before that says it was negligence. And perhaps that time frame of when we are contacted, when the corrections are, be helpful to nail down. The only other statement you made that I wanted to follow up on was he's no longer in office, and it is at the beginning of the stipulation, and the second sentence says, as a former elected official. Is that relevant that someone's no longer in office? Because we're looking at what was the events that happened in time, and in some cases, our resolution of these matters can take amount of time that goes beyond maybe even somebody's term limit or time in office, but that, how does the fact that someone's no longer in office play a role in this stipulation and the analysis?
It's not relevant to the violations that are here, but in other circumstances, we have had commissioners who have been curious, like, is this person still in office? Or what, could there be more violations going forward? So we try to include that information when we have it.
Understood. Thank
I can ask a follow-up on that, because I actually looked this up yesterday, because I was curious about it. And it's actually, in your presentation from December, you, I think, identified that as one of the potential mitigating factors.
Yes, it can be a mitigating factor, especially, well, so these particular types of violations, if the person's not in office anymore, obviously not going to be making any more governmental decisions unless it obtains another office at some point. So it can be mitigating at times. It depends on the circumstances of the case. But I think it also helps for context too, like whether someone is, like in campaign cases, you know, is this somebody who's continuing to raise money and wanting to keep moving forward with political activity, or is it somebody who the committee's terminated and they're no longer in office? So it sheds a little different light on the case. Here, I think it doesn't go to whether or not the violations occurred, but it helps in the general big picture context of knowing like where this person stands now.
Commissioner Wilson?
Yeah, I think it depends on the case, but I find that the, you know, information of whether an elected official is still holding office is valuable, because as we consider these cases, we're limited to the scope of the stipulation on what's the status of a particular individual. So it may not always be relevant in each case, but as a general rule, I found it, you know, overall that it's beneficial to have that information. So it gives you a sense of where that individual is, whether they're a current or former elected official.
Wood, anything on this item?
No, thank you. I agree with that.
All right, Commissioner Wilson.
This is a general question. Are there any options to increase this fine? And if so, what would be the process or hurdles we'd be up against?
So for these types of violations, we can, the conflict of interest, there was only one decision. So that is the limit of number of counts for that. For the failure to timely report gifts and the acceptance of the gifts over the limit, we could charge individually for each gift that was late reported and each gift that was over the limit. However, our practice is that we charge gifts that are late reported per statement. So here it's statements of economic interest. And so we will identify and group them together based on the statement that was filed, or the statement reporting period, pardon me. For the gifts over the limit, we typically charge the same way unless there's egregious circumstances where we want to charge separately. We didn't have evidence of egregious conduct here, so we chose to charge here in the same manner that we do typically.
Okay, thank you.
Any other questions for Chief Brereton? Hearing and seeing none, we have a motion on item 5 in the matter of Steve Dallas.
I can move to approve.
I will second. Is there any public comment on item 5? Hearing and seeing none, Ms. Linker.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
All right, moving to item 6. This is in the matter of Claire Crandall. Commissioner Wilson, I believe you asked to pull this item?
Yes, I did request this item be pulled, just based on, the stipulation that was prepared by Chief Brereton and her staff. On page 3, it says that the official, Ms. Crandall, used her position to influence a government decision, and it appears that she used her position to influence a decision which resulted in a contract with another county, Ventura County, and that contract that was entered into was as a result of information she provided based on the job that she held in San Diego. So I would like some explanation on why the fine is so low. I think the fine should be higher, given all of the financial, just say, situations that occurred based on the stipulation.
So in this case, we are proposing the maximum fine for one count of conflict of interest. You are correct that Crandall used her official position to influence a governmental decision of another agency, and she had a financial interest in that decision. Historically, we charge conflict of interest violations per decision. In this particular matter, the original contract that was in 2012 is outside of our statute of limitations, so we cannot reach back that far and charge, prosecute for that contract. We have a tolling agreement in place that preserved this violation. We have sufficient evidence to prosecute this violation. The stipulation gets the story out there. Crandall has admitted to the violation and to the facts and to the maximum penalty, and we believe that the maximum penalty is justified here. There was a high degree of public harm. Crandall used her official position to influence another agency to purchase the product of her spouse's company. We don't disagree with you. but our hands are a little bit tied since we are past the statute of limitations here. Crandall was, there was some mitigation, but we determined through our evidence and weighing all of the evidence that the mitigation didn't justify lowering the penalty from the maximum fine. And so in order for us to increase a penalty amount here, we would have to be able to charge more counts, but we don't have the evidence and to bring more counts under this case, partially because the statute of limitations ran.
While I understand your technical and legal reasoning, and to a certain extent I understand how your hands are tied, I just think that a unanimous vote on this particular item I think would send the wrong message. And while I realize that we cannot revisit this because that we're outside of the statute of limitations, I'm going to vote no on this, just for the record. Thank you.
Thank you. I'm sharing the same concern that my colleague has as well. I want to chat with you about the statute of limitations. You're saying basically, and I'm trying to stay within the four corners here. So there's definitely allegations going back into 2012. Was there a matter before us that the statute of limitations ran while it was before us, or did the facts that came into play not come to light to us until after the statute of limitations ran on those?
So, talking a little bit about delays in investigation, again, in general terms, sometimes we have difficulties obtaining documents, and that can be because parties are uncooperative. It can be because we just don't know where to go to obtain that information. It can be because the witnesses are uncooperative. So sometimes those delays can prevent us from obtaining the evidence that we need to realize that a statute of limitations may be running. So I don't have that information here in the stipulation for this case, so I don't want to speak specifically about this case, but in general terms, that can prevent us from taking action sooner than we're able to.
Because, the statute of limitations, I think I get what you're saying. And I know that this is second time a statute of limitations conversation has happened before the commission this year. And statutes of limitations is like the first thing you learn in law school, that if somebody comes in and chats with you, the first thing you say to them is you check the tolling and so on, because it's that big of an issue, and it keeps justice potentially from being fully put in place if statute of limitations runs. I'm trying to stay within the four corners here. So I'm seeing just enough allegations that there were violations of the Political Reform Act going back to 2012 that are not charged in here. And I think I'm going to take the same position as my colleague, Commissioner Wilson, because it's difficult to put a unanimous or even one vote behind one that happens. In this case, where we have facts alleged that go back in time, but we can't charge them. I do want to ask two more questions. One is this a matter that we would be able to refer to a local district attorney, or either against the respondent or any agency or individuals who in the course of the investigation may have violated legal obligations? Are you aware, or is that something that has been pursued? Is that an option for us?
It is an option. I know in this particular matter, we have worked with law enforcement throughout the process for this case. So we can certainly revisit that with them, but this is the resolution we came to from our investigations.
And I do want to say, I completely appreciate, because it did stand out to me, that we're charging the maximum amount in here. The penalty isn't, you know, the other stipulations we've looked at, they're for less than half, or they're a little bit above half. And sometimes in a stipulation, part of the reason why they're stipulating is they are going to get less of a fine than the maximum amount. I get that you've got the maximum here. I don't know if it takes a motion, but I would move that this matter and all the facts that are alleged in it be referred to the appropriate district attorney, whether it's Ventura County or I think San Diego County, for investigation today.
For what it's worth, I would
Chief
support that. I share a lot of these concerns. Sorry, Chair Matich.
Chief Brereton, I think in response to the question, unless I misunderstood you, you have been in contact with the DA's office. Is that what I understood?
That's correct. But I'm happy to reach out to them again. Yes.
All right. Well, I want to make sure it's clear on the record that it's already occurred, that contact has already occurred, and I'm totally open to visiting that contact again. I just want to make it clear that Chief Brereton did already.
Oh, I appreciate that, and thank you. It is very helpful to have the clarification. I guess I'm saying for our action as a body, as a commission, I make a motion that we refer it with for investigation beyond whatever contacts have already happened at this point, both to Ventura County and San Diego, and let them decide in their discretion what to do next.
Chief Brereton, coming back to the stipulation before us. First, I just want to, again, kind of for the record, this case dates back to 2016. This is well before you were the chief of enforcement, and essentially for bringing this case to resolution before us. So I appreciate your comments that statute ran for the reasons that you gave, but I also think it's important for everybody to understand that that happened well before you were sitting in that chair. Secondly, stipulation, I think, is very clear that the conduct at issue here, you know, I try not to do this, but I'll just say it in this case, it's some of the most shameful conduct we've seen by somebody employed by a government agency. It really is. It was a naked effort to enrich themselves at the public expense. It's wrong. And if I could, I would wave a magic wand and the statute of limitations wouldn't be an issue and we'd be charging this more than what we currently have. But what I'm also hearing you say is that having investigated this for 6 years, in light of the fact that we do have legal constraints with statutes and limitations, this is absolutely the best that we can do. So as much as I appreciate where my colleagues are coming from with their concern about approving the stipulation, sending the wrong message, if we don't approve this stipulation, which is the highest fine we can legally levy under these circumstances, what happens then?
We could pursue an administrative action, but if we pursued an administrative action, it wouldn't be a higher fine than this amount. Like, this would be the maximum for the count.
And now, that's true. So the end result is Ms. Crandall is still going to, at a max, end up paying a $5,000 penalty. But in terms of staff, time, and resources, we are spending an inordinate amount of time then litigating something to get to the same conclusion that we have before us today. Is that fair to say?
Yes, that's fair.
All right. I think that's important for us to remember, that sometimes even if we personally believe we would like to see something more done, that there are legal constraints here that we have to adhere to. And I think, you know, we have to be also mindful of the fact that our staff has spent time and energy bringing before us the best that they can do, which, again, I want to emphasize in this case is the maximum penalty. And so the consequence of not approving this today is they're going to have to do the work over again, spend more time and resources to get to the exact same place. There's no greater satisfaction for us at the end of the day if you don't approve the stipulation. So I just think that that's important that folks understand that's the consequence of not approving the stipulation that's before us today. So, do other commissioners have any further questions or comments for Chief Brereton on this one?
None that I can state publicly. Thank you.
All right. Do we have any public comment on this item? Hearing and seeing none, I will move approval reluctantly, but
Written public comment.
we have, for the record, we have written public comment from Mr. Winnick, who represents Ms. Crandall. Ms. Crandall is completely cooperative with the investigation, provided all requested documents, voluntary interview, other factors. I mean, the written public comment speaks for itself. I don't read it out loud. So I will reluctantly move approval of the stipulation as presented, with the additional caveat consistent with what Commissioner Baker recommended, that the matter also be referred to the relevant district's attorneys for further investigation.
I can
I
second
don't know.
that and really appreciate the conversation. Sorry.
Do I have to withdraw my original motion, which was to refer it, just because I appreciate, I do, since you have incorporated it within the stipulation, just for discussion on the motion, that because you have incorporated in there, I want to clarify, at least from my point, it's very important, it does get a specific, the commission, I'm hoping, will vote today that this be referred to both district attorney offices. And that given that the maximum result that we can get out of the action is the same amount we're talking about today, I will support this today. I will say this, I would also like to see, since this is the second time in, the second time in the last several months that a matter that's been before us in enforcement, we have learned at a statute of limitation that ran and prevented further action on claims, that we, if not at the next meeting, but perhaps in October, can get a report on what are our tracking mechanisms for statutes of limitations. And in the last 4 years, 5 years, I can nail it down more specifically, how many others have run where we have been unable to reach that. And I think that does go outside the motion, but I'm explaining my reasons for why I'm supporting this today, is we're going to get the same amount, which is $5,000, and that it will be referred for consideration to not one, but 2 district attorney offices for potential criminal prosecution or whatever their discretion sees.
Yes, I think you understand the motion correctly. For the record, on the separate issue about the report on statute of limitations, I agree we should have a future report from Chief Brereton on that issue, which we should discuss as a separate issue from. I agree.
And for the public, I want them to know that that's part of my rationale for why I'm willing to support this today. It needs to be out there.
We have a motion, and we have a second. Wilson? Wasn't sure if you were going to add, if you had anything to add.
Based on the, the clarification of the motion, and now that it's a two-pronged motion, and it includes a referral to the district attorney in both San Diego and Ventura counties, then I will vote, still reluctantly for the, for the motion, given the clarification.
I appreciate that. Ms. Linker, can you call the roll so we can?
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you, everyone, and thank you to my colleagues. I know that was a tough, bitter pill to swallow, but I do think it's the right thing for us to do. All right, moving on to item 10, pre-notice default in the matter of Isaac Galvan. And Chief Brereton, if you if you could, just spend a second explaining how it is that we have a potential default of $240,000.
Certainly. So this case, contributions are held in trust for to use for political, legislative, and governmental purposes. Here we have evidence that shows that Galvin violated that trust, and he used campaign funds for personal use. Additionally, many of the contributions and expenditures were made in cash, which interfered with the enforcement staff's ability to determine the true sources of the funds and whether any other violations might have occurred. These are egregious violations with a high degree of public harm, and Galvin was in office throughout the time that these violations occurred. He has not participated at all in this process, despite being personally served with the accusation. So under these circumstances, we are recommending individual accounts for individual payments, activities, campaign statements late filed, which we do not typically do in defaults. But here we find that the violations are egregious and there's a high degree of public harm.
You received any contact from the respondent here?
We have not.
Back to us next month then, assuming we don't have such contact.
Correct.
Any other questions for Chief Brereton?
Well, just hypothetically, Chief Brereton, what would happen if we were contacted in the next couple weeks or so, just from a process standpoint?
Our first step would be to gain compliance, because much of this activity was not reported. Campaign statements weren't filed. The activity was completely unknown to the public. So that would be our first step. So if he were to contact us, likely it wouldn't come back immediately, because if he is serious about working with us, we would want to gain that compliance, and that will take time. But we haven't had any contact up until now. So I'm not optimistic that would happen. I anticipate that the default will go forward. But I will notify you as soon as if that changes.
I've kind of a related question, Chair. You know, I've been on the commission since 2019, and this is the highest fine that I've seen. From a historical perspective in general, have we ever had a fine higher than this? I'm assuming we have, but...
Yes.
You know,
Galena can speak more to that than I can, but we have had fines that are much higher than this in some other matters.
Hello, Galena West. Yes, we've had, for intentional conduct, we've had fines much higher than this. And in fact, we just had that joint settlement with LA County not too long ago, where it was mailers and advertisements at public expense, which is one of the commission's priorities, and got quite a significant fine.
I was thinking more about individual fines. I should have been more clear on that regard, as opposed to governmental entities, but thank you.
Any other questions on item 10? All right. Any public comment on item 10?
Sorry, Chair Maddox. Yeah, just I would love it if we could get an explanation of what happens just generally for the public when people not only don't participate, but then don't take the fine seriously if they don't pay. Does it get referred somewhere else? This is just it's a blank that I have in my memory, but I also am thinking that the public might be interested in knowing this, since there's been like no participation so far.
Maybe you can give us a brief overview of collection efforts.
Sure. So if when a default is approved by the commission, the first thing we need to do is obtain a clerk's judgment. And so we present the default decision in order to the clerk. We go through that process and get the clerk's judgment back. Once we have that, we refer the matter to our administration division, and our administration division then proceeds to try to collect on the fine. We have multiple means of collection, including tax intercepts and such. I don't know all of the details. Larissa Hahn can probably go into more of those details. But that's generally our process. And then we have to, assuming that the fine amount is not paid for within a certain amount of time, we do need to renew those, the clerk's judgment every 10 years. So then we, and we have a process in place for doing that as well. I believe the legal division attorneys handle that process.
Thank you for that little education. I wondered if it was treated like other things that I've heard of, and it sounds like it is. So I really appreciate that.
Thank you, Chair Matich. I don't want to make a kind of follow-up to Commissioner Wood's question. I don't want to get too technical here, but based on your explanation, it's my understanding that this judgment would follow the individual if he or she, in this case he, was trying to get a loan or something along those lines, just like if you didn't pay a hospital bill, that judgment would follow you. Is that true? Or?
I shouldn't speak to that because I don't have a personal understanding, but I don't have any reason to believe that that isn't true.
Well, I think it's important. I mean, at some point, not necessarily, at today's meeting, I think that'd be helpful to share at some point so that when a fine is levied, that individuals understand that this particular fine has to be paid, and that this judgment would, potentially follow them if they tried to buy a house or a car or something along those lines. And then my related question is, $240,000 is quite a bit of money. When it comes to these larger fines, do we have a sense of what our success rate is in actually collecting the full amount of the judgment?
Hi, Galena West, Executive Director. We could give you a collections presentation, maybe end of this year or beginning next year, and we can talk about our success rates and what we do and what our procedures are in more detail.
Yeah, that would be helpful, because if it's a large fine that we don't get anything, it'd be good to know.
Right.
And kind of what our success rate. So the end of the year would be.
Okay.
End of the year, beginning of next year would be more than sufficient. Thank you.
We will take that on.
We do have a public comment that I want to acknowledge, asking if we can explain the timeline for resolution on 10 and what exactly is meant by pre-notice default. So pre-notice default is a procedure that the Commission instituted a couple years back, which essentially gives notice to the respondent who is the subject of a default that we are going to consider that default the following month and potentially to raise public awareness that this is on our radar, that we're poised to take action, hopefully to encourage the respondent to contact us so that we don't have to proceed by default and instead can resolve this by negotiated stipulation. As to the timeline, this would come back to us next month, assuming we don't have responsive to the public. If there are no other questions for Chief Brereton, is there any further public comment on 10 before we move to 11? None. Let's go ahead and move to item 11 in the matter of Laura Franco Perez. You wish to comment?
Only that we have not received any communication from Franco Perez regarding the default, so we plan to bring it before you for approval next month.
Any comment on item 11? All right, let's go ahead and take a 10-minute comfort on about 2 hours. So let's adjourn. All right, we'll go ahead and reconvene after our short break. Proceeding to our general items, which today are items 12 through 19. I'd like to actually begin, though, with item 14. That is adoption of proposed regulation to authorize the making of contributions via cryptocurrency. Presenting on this matter, I believe, is our Senior Commission Counsel, Zachary Norton.
Actually, it'll be General Counsel Dave Bainbridge presenting on this item.
All right, General Counsel Bainbridge.
Zach had the audacity to take a vacation in July, so I'll cover for him.
You approved it.
Yeah, but the reg project was originally going to be in June, so.
Bainbridge.
Been instructed to turn on my camera. All right, in May, this issue first came to the Commission as a pre-notice question of in which we provided a thorough overview of the cryptocurrency, both the nature of it as well as its use in campaign activity. At that time, we presented three options of what the Commission could do to revisit its policy on cryptocurrency contributions. Those options were, one, leave it as is, which is currently in regulation. The agency, or the current regulations prohibit the making of contributions in cryptocurrency. The second option was allowing cryptocurrency contributions of up to $100 in value of the crypto. And then the third option was the one that you see here today, which the Commission expressed a desire for, which is permitting contributions via cryptocurrency, of course, up to any applicable limits. So in response to that direction we received from the Commission at the May meeting, we've drafted the proposed regulations that are before you today. That regulation permits contributions to be made using cryptocurrency. And then in addition to that, we'd be rescinding the current regulation prohibiting contributions in cryptocurrency. I'll get into the specifics of the proposed regulation in a minute, but I would just note that in drafting this regulation, we had to address the inherent concern with cryptocurrency and the opportunity it presents for illegal contributions because of its, that it is inherently and intentionally in some circumstances anonymous. And in many circumstances, it's untraceable. So in drafting this regulation, we were cognizant of these very legitimate concerns, which was the reason the Commission 4 years ago prohibited contributions by cryptocurrency. And so we put some safeguards in place to try to ameliorate those concerns about cryptocurrency being able to be used to make contributions that are foreign contributions or that are through some sort of laundering scheme. And so I'll go through those the safeguards that we're suggesting that we think would alleviate largely those concerns about cryptocurrency contributions being anonymous. So the first one, I think the main one, is the use of these payment processors. So these payment processors are businesses that facilitate the transfer and conversion of cryptocurrency. They're used by businesses and nonprofits who receive contributions or payments or whatever the case may be in cryptocurrency and would like to convert it to money that they can then put in their bank account and more easily spend. So that's how they're being used today, and our proposal would be to add the political contributions to their business portfolio. And the way we've designed in the proposed reg, the system would go, it's similar to how the credit card contributions work, and then electronic contributions that come in through services such as ActBlue, and how those are treated and how those are transferred from the vendor who is actually receiving the money and then getting them to the committees for whom they are intended. So under the proposed regulations, the contribution the way we have it designed, the committee doesn't actually receive the cryptocurrency. The contributor would make the contribution in cryptocurrency through a processor. The processor would then convert the money to dollars and then transfer it to the committee. So a committee under the proposed reg would never be holding the cryptocurrency itself. It would be getting essentially the cash value of the cryptocurrency that has been contributed through the processor to that committee. The contribution amount would be the fair market value at the time the processor receives the crypto. So whatever that dollar value is at that second when it receives it and processes it, that's the fair market value of the contribution that would eventually be transferred to the committee in the form of dollars. So by preventing the committee from holding any cryptocurrency, that avoids concerns about the possibility of manipulation of value after transfer. There had been concerns expressed that as volatile as cryptocurrency is, if committees are holding it, could the person who had given it to the committee then somehow manipulate the value of the cryptocurrency? That won't be an issue here because the crypto will essentially have already been cashed out before that happens. And then also, I think key to this scheme is the payment processors must employ know your customer protocols that verify the identity of the contributor and then also obtain the personal information of the contributor, which is required for campaign reporting. So in receiving the dollars from the crypto contribution, the committee is also going to be receiving the information it needs to complete its Form 460 about the contribution it received. So name, address, employer, profession if it's an individual contributor. The processors that the committee can choose to employ to receive the cryptocurrency must be registered with FinCEN, which is a portion of the Federal Department of Treasury that licenses these sort of processors, which has some benefits. It makes them subject to federal regulations in this area. And the other requirement we have in the regulation is that the processor be based in the U.S. This is to ensure availability of records for audits and investigation purposes. Zach had done some research and reached out to a few of these larger payment processors and confirmed that they have processes for receiving subpoenas, that they accept subpoenas and that they're responsive to subpoenas from government agencies. So we've at least talked to a few of them. Obviously, some new ones can pop up. I think that's kind of the challenging thing about this area is it's very dynamic, and these payment processors are fairly new businesses, but the federal government has gotten into regulating them, which I think gave us some comfort about their legitimacy, and to know that there's this underlying requirements. The federal laws have know your customer protocols of their own, so they're already going to need to have payment processors already going to need to have these sort of mechanisms in place to help ensure that they know where the crypto money is coming from and they can document it, which was a lot of the concern expressed both by the commission in the past as well as public comment on the question of cryptocurrency contributions. So those are the suggestions we have for sort of the safeguards, the guardrails to put in place to ensure we know who is contributing to campaigns. It's one of the central purposes of the act, that we know who is making contributions to campaign committees. And then the mechanics of the payment processor transaction are designed to be similar to the rules for contributions by credit cards and electronic fundraising services, like I mentioned before. So I think the committees will be familiar with this process. The amount of the contribution is the full amount given. If there's any fees, which the processors usually have a small percentage that they take, those would be considered expenditures just like is done with credit card contributions today. So hopefully our goal is that this would operate in a very similar way to credit cards, except instead of being a credit card, originally the money came in the form of a cryptocurrency that had been cashed out. And then I would just note that this is a very, very new and ever-changing area, and so especially in the campaign finance context. Last time around, Zach did a really good job with his memo of going through what a lot of the other states do, what the federal government does, and it's all a little bit different, and I think everyone's kind of trying to figure it out. So I would just say we may need to adjust this as the industry develops. It's a fairly new industry, but I feel pretty confident that this regulation at this point does a good job of finding a balance between allowing contributions to be made in crypto, but then ensuring that it's not going to become an easy avenue to violate the law. So with that, that's kind of a general overview of the regulation. If there's specific questions about the language, let's take those now.
Thank you, Mr. Bainbridge. And again, let me just my thanks to Senior Counsel Norton, who did spend a lot of time, I know, researching and putting a lot into the best approach. So I did have a question and perhaps some suggestions on the language in the regulation, which I think are in the nature of more technical changes. Page 1, this is in B1. We talk about the Know Your Customer protocols. In B1, though, we use what I think is maybe some extraneous terminology. We talk about adequate KYC controls that enable it to form a reasonable belief that it knows the true identity of the contributor. I think, for my sake, it raises some questions. What do we mean by adequate procedures? How would a committee know the difference between what's adequate and not adequate? What is a reasonable belief? And certainly the true identity, I think we should just assume we want to know the identity. So for my mind, I think that sentence could be tightened up by simply reading has KYC procedures that enable it to know the identity of each contributor. Because I think that's what we're really saying. I think that's an important part of the regulation. Those procedures enable the processor to know who's contributing. That's the information we want. So I don't think we need to qualify it in all the ways that we have there. That's my first comment. Second comment I had goes to B1, line 21. The amount of the contribution is the fair market value of the cryptocurrency at the time the payment processor, and we say obtains possession of the contribution. I flag that obtains possession language because I think what we mean is when they receive it. But I think what we want to perhaps say instead of obtains possession is at the time the payment processor converts. I think that's right, because isn't it we want to fix the value at the time of conversion? And is there a difference, is I guess the question, if we were interpreting this, is there any difference between the time of conversion in 3 and obtaining possession of the contribution? I don't think there should be any daylight between those time periods. I think it should be the exact same moment in time, but I just raise that for consideration.
I don't know the answer. My assumption is the same as yours, that all of this happens instantaneously. We could look into that and come back, or if the commission's will is to change the language now. I don't know if there was a specific reason for obtains possession, but I don't see a distinction between the time it's converted to the time they obtain possession. I think it's probably, like I said, I believe it's instantaneous. Okay,
so for purposes of the record then, as we're adopting this, you don't see any distinction between those. So we have a clear understanding then that the amount of the contribution is the fair market value of the crypto at the time the payment processor is converting that contribution.
Right. Okay. And I think it's mostly up to the way the payment processor operates, right? So yeah. I guess the more general term we could use probably receives. I would recommend saying receives if that's the process they use.
So receives the contribution.
Mr. Chair.
Good.
I think, I don't know, maybe I can't remember well, but I wonder whether any window that exists could push somebody kind of over the contribution limit in a way that's unhelpful. And so you want to go with the earliest possible time. So I also agree with receive, but I wanted to give a possible justification for why it's in there that way, as opposed to when the conversion happens. Because if there's daylight between it and the cryptocurrency is inflating in value against the dollar, then that could push it above the limit. And then that's just a pain for everybody, right?
Yeah, and that's what I'm trying to avoid. I'm just trying to make sure that we're all of the same understanding, that it is happening at the same time and the processor can't hold it and allow for manipulation, essentially, of the value.
And it's been pointed out to me by the executive director that receives may not be the best word to use because they're not technically receiving a contribution as that term is used under the Act because the contribution is not for them.
Right.
So I think we want to use a term that's not used in the Act.
I'm sure that's why.
Probably.
Obtains possession.
If he wasn't hiking in Yosemite or wherever he is right now, he could tell us that. Yeah, I'm open to other wording. I think we all mean the same thing. I don't know that obtains possession or that the time of conversion, I don't know that there's a distinction between those. I mean, what we mean is when it hits them as soon as they can process it, that's when it sets the value.
And I'm fine with that. I think it's important that you say that so that we understand that there is no daylight in our interpretation of this regulation. It is intended that it happen instead.
Yes, that's correct.
I was just going to clarify, we could do it as whichever is earlier, obtains possession or converts, whichever is earlier, in order to make sure there's no gap, instead of trying to figure out the right word.
All right. Those were my two comments. Let me open it up to other commissioners.
Thank you. I spot on with B1 and removing essentially the adjectives, and I think they're all adjectives. There could be an adverb in there, but the way that you had written it, I think is appropriate because otherwise we're asking questions according to whom is it adequate, reasonable to whom, is it your treasurer, is it the campaign, and otherwise. So I believe the language that you articulated was has KYC procedures that enable them to learn or know, to know the identity of each contributor. That's it. That's the language you're proposing. I would agree with that. I have a couple of quick background questions. Is cryptocurrency defined somewhere else? Because there wasn't a definition here, and it might be that it is defined somewhere else, or can you answer that?
It's not defined in the Act.
Okay. Do we need to have a definition?
My feeling is it's fairly known and understood term as to what it means. My concern with trying to define it is that it might be too difficult to define. I think it's fairly well known what it means. I mean,
I think I know what it is. I think there's a common understanding, but I'm always looking for ways in which someone who's going to try to get around the rules says, well, this isn't crypto. I don't know what other option they'd try to fit in with doing. I think I would just keep an eye on that as we, over the course of time, as this is implemented and maybe cases come before us, or we learn of practices, just to see if we have to get specific with the definition. Pro and con is, it's difficult to define when everybody understands it, but also does it make it clear? And I'm assuming U.S.-based is also sufficiently clear that, at least that we're going to be able to serve subpoenas and they have some sort of presence within the reach of U.S. law. I don't know that that has to be defined either, but as I was looking at this and just knowing if this is a different world for transactions, just making sure we understand what that definition is, or if we need one. I don't know if we do, but I threw that out there. With respect to this obtains possession or otherwise, I noticed in the prior section 3, the processor has to immediately convert it. So, if we're trying to trigger it as immediately upon what? And that whenever that happens, that needs to be what the fair market value is. I'm inclined not to mess too much with obtains possession because I'm deferring to some degree to Mr. Norton, who's done an excellent analysis here, because I think that is possession. What little I can remember is that means you control it. You control it and you can convert it. So I'm reticent to try to change it beyond what's here. Noting that we could come back in 30 days, I'm game for adopting this today because I think that the timing is right. But if there's any uncertainty, I would encourage us to follow up on that rather than try to go back later and fix it. I want to thank the team for excellent analysis for this commission on this field and the possible options. I think this has been excellent. You're seeing it in the public comments. And finally, when would this be effective?
Unless we set an effective date, it will be effective 30 days from when the Office of Administrative Law sends it to SOS for publication. How long that takes can vary. I'd say typically it's about 60 days before the sort of ministerial process takes place.
Okay. And during that time, do we anticipate any education resources that we'll need to make available? I mean, we're not going to tell folks, here's the payment processes you have, but, you know, there's an election coming up, and we're getting right into general election season. When lots of contributions happen, the most of them, will we be doing any particular education outreach for the most immediate time?
We'll do our typical outreach, which is anyone who signed up for our list will get updates on updated regs. It'll be on our website. I can ask the education group, people who are giving campaign trainings, to mention it. This will be going into effect soon. I'm hesitant to do too much until we know the exact date that it will go into effect, because that's always the follow-up question. And once we know it's gone over to SOS, then we can give the exact effective date, and we'll also put that on the website. I think in this instance also the press will be helpful in providing information to the public that this change in policy has taken place.
Yeah, I think that'll be helpful. And I know we get the reports on the trainings that are available to candidates and treasurers that as soon as it's effective, I'm sure we try to at least get some mention. And my final one is just understanding the practical, how this will be reported, how a transaction will be reported so that people are aware that what a candidate received was, or a committee received, was came in crypto, was converted, and put in, what, can you kind of spell that out for the public?
Sure, it'll be reported like a non-monetary contribution is reported, so it'll state the value of what the item was, the person who provided it, and so just like any other non-monetary contribution. And I'd have to pull up the form to exactly, I don't remember if I think the nature of what the non-monetary was is also listed on the form, if I remember correctly.
Yep. And I think that's just for folks knowing that. I do just want, for fair disclosure to my colleagues, we have a practice and policy that if we've talked with people about an agenda item that comes up to us, I did have conversations with Controller Yee about this, someone who deals with a lot of state transactions and finances, and I just disclosed that to my colleagues and appreciate the hard work on this regulation.
Commissioner Wood, any additional comments?
No, I was just sitting here thinking about how grateful I am to the legal division and the work that they do in this. It's been really careful, thoughtful policymaking, and I think the people of California should have really good confidence in our legal division. So thank you so much for all the work you've done. And pass that on to our hiking companion, please.
Yeah, thank you. For the record, I don't know what he's doing on his vacation, but Zach has done a great job on this and done a lot of research and really dug into an area that I think is initially intimidating for people who don't understand what cryptocurrency means. So he gets almost all the credit for this one. Do
we have any, I know we've received some digital public comment, which I want to acknowledge. Do we have any telephone public comment or other public comment on this item? Hearing and seeing none.
Mr. Chair?
At this point.
Sorry, before you entertain a motion, I just wanted to respond to the public comment that we received, which all I wanted to say was to reiterate something that Mr. Bainbridge said, which is that, you know, it is important to remain flexible here. And I really appreciated the CPA's willingness to kind of come back and let us know how it's going. Since they're the regulated entity and the one who's going to be most affected by this. And I assume most of us will remain really open to making changes if we need to make changes. So good luck to them. And thanks for the comment.
Thanks, Commissioner Wood. Commissioner Wilson?
Yes, in terms of the, discussions we've had about with the public and outreach committee, where our website is really very informative in terms of being able to navigate to various issues. Mr. Bainbridge, you had talked about putting together some information that would be on the website. And I think that the staff memo would be excellent to put on the website so that as people have questions, if you read the memo, most of the questions that I had were answered. So just easy access to this information on our website would be a good idea, and to, as you suggested, and to include the information that's in today's staff memo. Thank you.
All right, any further comments? Right. All right, at this time, I'm going to move adoption of this regulation with the following changes to B1. B1 would read, as KYC procedures that enable it to know the identity of each contributor. That change to the language, I'm moving approval of this regulation.
Commissioner Baker?
I can
Aye.
second. I'm sorry.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye, sorry, I didn't hear it.
Chair Madich?
Aye.
Motion passes.
All right, thank you, everyone. Appreciate it. All right, so we will work. Now we will go back to item 12, which is our pre-notice discussion of proposed amendments to Regulation 18960, direct personal benefit, made at the behest of independent versus coordinated expenditures, et cetera. And I believe, nope, there she is. We have Senior Commission Counsel, Ms. Harrison, with us. Good afternoon.
Good afternoon. Good afternoon, Chair Madich, Commissioners Baker, Wilson, and Wood. Karen Harrison, Senior Commission Counsel with the Legal Division. I'm here to present for pre-notice discussion proposed minor update amendments to the three regulations that were named. That's 18960, 18225.7, and 18728.5. These changes reflect recent legislation, regulatory changes, and some citation cleanups. I'll pause after I discuss the first regulation for questions and then continue on to the other two. The first regulation is Regulation 18960, which provides the definition of a direct personal benefit in the context of the personal use of campaign funds prohibitions. Currently, Regulation 18960 defines direct personal benefit only for the purposes of one statute, and that's Government Code Section 89511 in Subdivision B3. And that's where it discusses the statutory definition of a substantial personal benefit, which is defined as a direct personal benefit with a value of more than $200 to a candidate, elected officer, or any individual or individuals with authority to approve the expenditure of campaign funds held by a committee. Now, in 2021, legislation was passed to amend a different section, 89521, to address the personal use of campaign funds that results in an egregious personal benefit. The definition in that statute of egregious personal benefit now includes a reference to a direct personal benefit. It's defined as a direct personal benefit with a total value of $10,000 or more to the same list of folks that are authorized to approve expenditures from a committee's campaign funds. So staff is proposing that we add language that makes the direct personal benefit definition in Regulation 18960A applicable to both statutes, the recently adopted Section 89521, as well as the current section that it references. Staff has also identified some other items in the regulation that can be addressed, and I'll just go through them in order of importance. First, the regulation defines a direct personal benefit in terms of a $200 threshold. This threshold is unnecessary given the statutory language defining a substantial personal benefit in Section 89511. Also, it's potentially confusing now that there's another term that has a different threshold amount. So staff proposes that the threshold amount in Regulation 18960A1 be removed. Second, Subdivision A of the regulation does not include in its lists of persons to whom the regulation applies the terms any individual or individuals with authority to approve the expenditure of campaign funds held by committee, although such persons are identified in both of the sections that are important here, 89511 and 89521. So to be comprehensive, staff suggests that that language be included to list those individuals in the definition. And last, subdivision A2 uses the term actually, stating that one must actually make personal use of an asset obtained as a result of an expenditure. The term actually is unnecessary, and staff proposes that it be deleted. So I'll pause here for any questions before I go into the next regulations.
Thank you. I'm just curious if you happen to know why the $200 threshold was there to begin with. It seems sort of like an allowance that, you could benefit in some way up to $200. And I don't know if that was the result of folks just found it was necessary originally to have some kind of dollar amount. Can you speak to that briefly at all?
I looked for some background. I did not find anything to answer your question. However, it may be helpful to know that these two sections that I've been discussing are the only two sections that refer to a direct personal benefit. So it doesn't show up elsewhere in the Act. So all I can say is that it seems that that $200 threshold, it just complicates matters here.
Thank you.
Are there questions for Ms. Harrison? All right, please continue.
All right, so going on to the next two regulations. These are pretty minor cleanup matters. Regulation 18225.7. This deals with made at the behest of payments and kind of explains the difference between independent versus coordinated expenditures. And in that explanation, there's a reference to readers to look to Regulation 18215.3 for further guidance on a particular type of behested payment. That regulation was repealed recently by the Commission in 2021, and the reference is not relevant because of the repeal, but it's also not relevant because it's just not really necessary in the way that the statutes and the regulations have developed over the last couple of years. So we recommend, staff proposes that we remove the sentence entirely, and it need not be replaced with any further reference. And then moving on to Regulation 18728.5, reporting of commission income and incentive compensation. It currently has an incorrect citation to Regulation 18703.3 for the definition of commission income and incentive income. And staff proposes that we just correct the citation to the correct regulation, Regulation 18700.1. And it appears that that was just an oversight when there were some amendments made to these this portion of the regulations. Are there any questions?
Thank you, Ms. Harrison. Any additional questions for Ms. Harrison? All right. Is there any public comment on item 12?
Your conference as the host or a menu.
Stand by. All right. Any public comment on item 12? All right, hearing and seeing none. Thank you, Ms. Harrison. Appreciate it. This is on pre-notice, so this is scheduled to come back to us then in September, correct?
That's correct.
All right, excellent. We'll see you in September then.
Thank you.
Thank you, Ms. Harrison. All right, we'll then proceed to item 13. This is adoption of proposed regulatory changes regarding requirements for referrals and public information and records requests for pending enforcement matters. And I believe we have two of our council joining us today. We have Commission Counsel Kevin Cornwall and Commission Counsel Torrin Lewis. Good afternoon.
And this is Dave Bainbridge again. I'll just chime in to remind you that we originally had two regulation packets, and then at a certain point we realized they were going to touch on the same section of the regulation. So we've combined those, and that's why we have two staff members instead of one. So they're going to break it up by subdivision.
All right, good afternoon, everybody. So Torrin Lewis, Commission Counsel with the Legal Division. As discussed, my colleague Kevin and I are going to be discussing proposed changes to regulation, I should say existing regulation 18360. I specifically will be discussing the portion relating to requirements for referrals to the Commission's Enforcement Division. You may recall that these amendments were presented, or at least my portion of these amendments, to the Commission for pre-notice back in May. Following some public comment as well as input from local filing officers who we actually followed up with subsequent to that meeting, we've made some changes and incorporated feedback. And actually, at that time, we had also proposed making amendments to existing Regulation 18115, which lays out the duties of filing officers. But again, following discussions at the previous commission meeting and subsequent conversations we've had with those local filing officers, staff has decided that the changes to 18115 are not necessary at this time. And for reasons I'll explain and I'm happy to discuss, we think we can accomplish the same aim as by simply amending Regulation 18360. So in short, what these proposed amendments would do is to provide a comprehensive list of information that filing officers should provide to the Enforcement Division when making Statement of Economic Interest, or SEI, or campaign referrals to enforcement. Most of this information, if not all, is already requested on the complaint form, which is filed via enforcement's website. But the idea here is to clarify and codify that information to really streamline the enforcement intake process as it relates to referrals. Some quick background: the Act, of course, requires filing officers to report apparent violations to the appropriate agencies, including the Enforcement Division. Typically, this is done by filing a referral to the Commission through the electronic complaint system on our website. Subdivision A of Regulation 18360 in particular details the requirement for filing such a complaint. Enforcement intake in particular, which is a team of around 5 staff, has informed us that they receive approximately 100 referrals per month, and they've observed a pattern of referrals containing either insufficient or unclear or outdated information. And of particular note was that sometimes local filing officers will send leaving office SEI notifications to the non-filer's agency email address on file after they have left office, and then refer said people to the Enforcement Division, which of course eats up a lot of staff time and resources following up with such referred individuals. And in addition to taking up staff time and resources on our end at the Commission, this also creates significant delays with actually processing and handling these referrals for all involved. It means that non-filers may also be referred to enforcement without actually receiving notice and of their failure to file, and therefore the opportunity to actually file before being referred for an alleged violation. So that's kind of the backdrop against which all this is happening. And so as far as the proposed amendments themselves, again, I'll just reiterate that we heard public comment back in May from Los Angeles County and had subsequent discussions. And I think if I were to highlight the main sort of result of those discussions that we changed is instead of focusing on the duties of filing officers, again, what we're doing here is clarifying what information they should provide. And with respect to one detail, which I'll list in a minute, which is providing personal contact information where it is available to the filing officer of the referred party. specifying that filing officers should use best efforts to provide this information where possible. Just to clarify that we're not imposing any kind of new duties. This is not about penalizing filing officers, but rather just stressing that if that information is available, to include that as part of the referral. So in order to accomplish that, staff is recommending amending Regulation 18360A3C, and this would require filing officers to include as part of a referral information regarding all attempts to obtain compliance, including the email address, mailing address, and phone number at which the referred person was contacted. And further changes would specify that for those officials who have left office, which again is sort of a primary concern here, the contact attempts should be made to a personal address, home address, or personal email address, I should say, home mailing address, or personal telephone number, where it is known if the filer cannot be contacted through their agency contact information on file. Next, we recommend adding a new subparagraph D to the regulation to specify that in the case of campaign referrals, filing officers should also include a copy of the most recently filed campaign statement, if any, committee name, ID number, and the candidate's name in the case of a candidate-controlled committee, the office sought or held, the name of the treasurer, and current contact information for them. And then the last requirement would be including information about the filing methods available to the filer at their agency, such as paper, electronic filing. And this is relevant because sometimes non-filers will generate an automatic message, and it's relevant to the Enforcement Division determining what happened and how the non-filer was contacted or not in such cases. The last subparagraph we recommend adding is subparagraph E, and this essentially clarifies what information, analogous information, should be included in the case of SCI referrals. And so that would be a copy of the most recent SCI, the conflict of interest code, and once again, personal contact information such as personal email, home mailing address, or personal phone number that is in the possession of the filing officer. And also that filing officer should make best efforts to obtain such information, including requesting it from the filer. And lastly, requiring written confirmation from the filer's agency as to whether that individual is still active or employed with the agency. Again, this would help clarify this in situations where people are gone, but it's unclear, are they on a leave of absence or they've left office. And on that note, the last recommendation from staff is adding a new subsection A4, and this would provide that where a filing officer does receive a filing from a person who they've referred, to notify the Enforcement Division within 7 days of that receipt, so that Enforcement Division is updated on those facts. So that concludes my portion of the presentation. Happy to answer any questions or turn it over to my colleague, Kevin Cornwall.
Thank you, Mr. Lewis. Appreciate it. Do commissioners have any questions from Mr. Lewis on regulation regarding?
Yes, well, I just have one kind of question or recommendation, which probably wouldn't be necessary if every filing officer was thorough as Mr. Lewis and Mr. Cornwall, but my question is, if I'm a filing officer, I obviously, and this regulation is adopted, I obviously can go read the regulation. But what kind of training materials exist now for filing officers, whether they're a new filing officer or someone who wants to just make sure they're up to date on the current regulations in place?
Torrin, I can take this one. Dave Bainbridge, General Counsel. I'll take this one from Torrin. The education group provides trainings to filing officers, and so we'll incorporate this into our training to let them know that there's now much more specific requirements for filing a referral that's contained in the regulation. The other thing that would help them is that in filling out the form online, there's required fields. So it kind of takes care of itself as you're filling out the form. It tells you what you need. Our hope with this is the filing officer can have this sheet, have the regulation, and know exactly what they need to collect before they go sit down to submit the referral. But if they don't know that information at that point, they also, once they sit down and start trying to fill it out, they'll know what they need to provide.
Assuming they know how to use the computer, right? Which I'm assuming is the case. But I do have one recommendation, and it's something that I would defer to all of you, whether it would be helpful. Everyone is not going to read the regulations in detail. The fact that the form will force them to, or direct them, should I say, to provide certain information, I think is a brilliant idea. But it also might be worth considering, and I'll defer to all of you whether it's even a good idea, to have some kind of checklist where the filing officer would have, hey, here's your 10-point checklist, here's your 15-point checklist, 5-point checklist, so that if a filing officer is used to doing things a certain way, they'll kind of be directed to do it. With the form, though, I think that's a brilliant idea that will force them to utilize, the right, or fill in the correct information. So, thank you. Mr. Baker?
Thank you, and thank you for bringing these forward. Anything that can help our enforcement team get to focus on the meat of what they really want to be able to focus on instead of tracking down information that can hopefully come from someone else without too much burden is great. Support all of these. One question I had, and when I think it's in the SEI context primarily, but if it can be anywhere else, is I appreciate that you have a request for, if available, best efforts to get personal information, especially if the official has moved on out of that agency. You mentioned personal address, phone, and email. It's possible they have a work email. Are you anticipating by personal you mean also whatever, or professional? If you think it is helpful to provide that extra option on the form or in the regs themselves, I would just throw that out there because it's possible the person's moved on. They'd have to hunt down for their home address and home phone number and home email, but they might know where they work now. So don't know if that adds anything or if it's already encompassed in what you have. And I guess on the last one, and this goes to campaigns, requiring for campaign related referrals to have much more information, so it's kind of packaged, I think is excellent. Did you get any feedback in the outreach process that might make anyone less likely to file, pass these on? It's like, gee, I got to get a statement, I got to get all these things. Can't the FPPC do that? Well, maybe, but you can do it too. So did you get any feedback or pushback on that as a potential disincentive to file those complaints?
I think we initially did, thinking back to the public comment at the May Commission meeting during pre-notice. I feel, having spoken with local officials since then, that there's been less reticence since this is not creating a new duty on their end, but in essence is just serving to shed some light on the specific requirements that enforcement needs. There were some recommendations floated about could we amend the forms or things like that, which of course is outside the purview of this specific project. But by and large, I think we have more consensus now around this required information than we did back in May. Okay, great.
And perhaps there's a feedback loop that continues in the future during the annual trainings that are for filing officers and otherwise. I'm sure you would already be alert to the fact if something sounds like, look, I'm not going to bother because I have to go out and do some work. Obviously, I'd hope that they would still bother and have some rigor to it. But hope you'll just keep ears to the ground on that. Sounds like you already have, and I appreciate that. So thank you.
Yeah, if I could just add one thing that I forgot to mention, Commissioner Baker, which is the local filing officers we spoke with also stressed that this is something they already oftentimes will take pains to do. I can't speak for all of them, but it's just in certain cases where large municipalities will have many boards and commissions, and there will be certain individuals who end up being difficult to track down. But we do know a lot of them take proactive steps to get as much information as possible.
Very helpful, which goes to show that it is not too much of a burden to track it down and pass it on so that we can do our work. Thank you.
Commissioner Wood?
I wasn't sure if I heard it correctly earlier, so, and I know this is outside of the scope of the regulation, but just as somebody who does a lot of online surveys in my own work, we don't, the checklist approach that Commissioner Wilson brought up is way better than like a mandatory field approach, because people will just throw up their hands and walk away. And so when it gets to the stage of incorporating some of this into the forms, we just want to, oh, you can't hear me? Oh, y'all can't hear me at all? Oh no. Okay, I'll email you. Okay, just do it over the computer speaker. Can you hear that? You can't hear this at all? Okay, forget it.
Mr. Cornwall, please continue.
Okay, so in addition to the amendments discussed by my colleague, Mr. Lewis, we're also proposing the Commission adopt amendments to Subdivision D. That subdivision addresses how the Commission responds to public requests for information and records regarding a pending enforcement division matter. As noted during the pre-notice discussion at the April Commission meeting, the proposed amendments would generally codify the approach Commission staff already takes. For example, the proposed amendments would make express that aside from providing public records and general information, like the current stage of an administrative proceeding, Commission staff will not comment on a pending enforcement matter. The most significant change that staff proposes is shortening the period between providing notice to the subject of an enforcement matter and releasing general information to the public. Currently, Regulation 18360 includes a 5-day delay between the commission, before the commission may provide information or records relating to a pending enforcement matter. The length of this period served a greater purpose in the past when the presumption was that notice was delivered via physical mail. Today, however, notice is primarily given via email or a combination of email and physical mail. Given the instantaneous nature of email, staff believes a 5-day period is no longer necessary to ensure a respondent is made aware of a pending enforcement matter prior to the public and would help increase transparency with the public regarding pending cases and, more generally, the work that the Commission does to enforce the Political Reform Act. However, based on feedback from the Commission at the April meeting, staff has further amended the regulation such that the shortened period between providing notice and release of information and records to the public would only apply when notice has, in fact, been provided via email. In the rare circumstances where notice has only been provided via physical mail, that period would remain 5 days. Finally, the Act would also reorganize Subdivision D to make its provisions more clear to the public and the regulated community. As included in the agenda, we received letters of support from the California Broadcasting Association and the California News Publishers Association. We also reached out to the California Political Attorneys Association, and the only suggestion we received echoed the Commission's request that the 5-day period be preserved where notice is only provided via physical mail. For these reasons, staff recommends the Commission adopt the proposed amendments, and I can answer any questions the Commission may have.
Any questions for Mr. Cornwall? Wilson?
I think this question's been answered before, but for the benefit of the public, are we talking calendar days or business days?
Calendar days. We had discussed it at the pre-notice, right. And we were, not only were we mirroring how it was written before, but also when we further considered the calendar versus business days, there would be scenarios in which doing business days wouldn't result in much of a change compared to the way the regulation is written now.
I know you had previously clarified that. I just wanted to be on the record for this meeting. Thank you.
Commissioner Wood, I don't know if you have any questions for Mr. Cornwall, if you're...
I don't. I heard most of it. I actually ended up logging into YouTube for a little bit so I could hear it until the Zoom got fixed. So I'm all set.
Okay, great. Thanks, Commissioner Wood. All right, do we have any public comment on item 13, either of the two regulations, item 13? Hearing and seeing none.
Chair, can I have a minute to speak with staff real quick?
Sure.
And sorry, apparently there was a drafting error. Subdivision.
Is your mic on?
Oh, yes. Subdivision F in the regulation that was submitted on the agenda and was not underlined, but that should not have been included. It was originally a suggestion, but ultimately we decided that the purposes of the regulation would be better served without the subdivision. So we would remove subdivision F for the proposed regulation.
Say that again. I just want to make sure I got that. Sorry, I apologize.
So subdivision F, when sending a form of notice to a respondent or complainant via email, enforcement division staff shall include a request for a read receipt. A returned read receipt is not required prior to providing information to other parties as specified in this regulation. Staff is not recommending that this subdivision be included, but is willing to answer any questions that the commission may have regarding it or take further direction.
I understand why the second sentence may not be necessary.
Mm-hmm.
But what's staff's rationale for not having a policy of including a request for a read receipt when sent? Why not do that?
So with respect to the request for the read receipt, if we were to use just the standard, what's included in most email software, the request for the read receipt can be ignored or rejected. We also don't want to create a false impression that the read receipt, I know that the second sentence clarifies that it isn't legally binding or anything, but with any form of notice, it's based on when the notice is served. And so in this instance, we don't want to create a false impression of what the relevant date is for the recipient.
Commissioner Wilson?
Yeah, just because I'm on the same committee with the chair doesn't mean I'm an expert on technology, but I know that there is technology out there where I could send you an email right now and tell you exactly at what time you open that email. Now, if you use Microsoft Outlook, the recipient can decide, well, you know what, I'm not going to click on the read receipt. But there is technology out there where the recipient doesn't know that you're tracking the email. And as soon as they open the email, you're able to verify what time it was open. But because that's just an additional way of verifying whether something is received. When it's provided, when it's delivered in person, obviously you can track that through a server, process server, and so forth. But tracking read receipts it's very common technology that's out there.
I understand that, and I understand that there is software that could be implemented, but for the immediate, given that we don't have a particular software picked out for this at this time, I think that was something that we would want to further explore down the line.
At least be optional, where it's if feasible or if practical, determined by, because in the era of all the technology that's out there, it is possible to send someone an email, and then they respond by saying, I didn't receive your email. And you can say, well, actually, on July 21st at 8:30 a.m., you did receive it.
I think in that instance, I agree that in most cases, personal email, there might be some, we might assume that that person has exclusive access to it, but there would also be instances in which, they could claim that they aren't the, person with sole access to that. I think it sort of creates, in some cases, an additional issue to litigate that isn't entirely necessary for prosecuting or proving a case, enforcement matter.
What if I say, I didn't receive your email and I don't know what you're talking about? But you know that I received it because maybe I guess it cuts both ways is my point, that somebody can always deny that they didn't receive something.
I'll jump in here. So the receipt of the complaint doesn't then trigger something else. So it's not like if you're served with a complaint in a civil case, you then have a certain amount of time to respond to that civil complaint. So I think the read receipt, what we determined, we obviously thought about it. We took the took the time to draft the language. Ultimately concluded, one, it creates one more thing for enforcement to have to do. And if they don't do this, what does that mean? Does that mean the case was never opened? It creates more issues. And I think ultimately the benefit of it, obviously knowing that someone did receive it is useful. And I think it's a policy that enforcement may very well want to adopt for their own sort of purposes of, yeah, you did receive it. Look, we have but we ultimately came down on adding it into the regulation, making it a requirement of something that gets done. The benefit received from that didn't really outweigh sort of the troubles that it could create and the additional sort of just ministerial work that could come of it.
I mean, I understand that. I mean, to the extent, your policy, even if it's not in the regulation, would be to use every effort to track and verify an email in an era where technology is used by everyone virtually who's in business or, in government. I think that would be sufficient. But I think if it's not in the regulation, it should be part of the business practice.
Commissioner Wood, I think you had your.
Well, I don't think I was going to add a whole lot, just that, I was plagued with read receipts that were automatically sent from my Outlook for a long time because I had the preview pane open, and then I had this other thought that my kids know the password to my phone, and so they could open it and access the email. So I just think the read receipts, it's almost like in political science we talk about measurement error, that they might be suggestive that an email was received, but they might not. And so I'm okay with it not being in there. I don't think it's my vote doesn't rise or fall on it, but I just wanted to include that.
Thank you. Chief Brereton, I hate to put you on the spot, but I want to check my own recollection. I believe when we first talked about this proposed regulation back in, did ask whether it's your regular practice to include read receipts. I thought you said yes. I don't want to put words in your mouth. So I want to, since I think that's an important thing to clarify on the record, whether that is our existing policy, can you confirm or deny my recollection?
Sure. So it is not our current policy. Some of our intake staff do use them, some don't. None are opposed to using it if we want to be able to verify in some fashion. I agree with some of the comments that it does add some additional work, because it really, I think they would have to turn it on for the specific email that they're sending out regarding sending out the actual complaint or the we will investigate letter or, whatever stage we're at, or have it on for every single email. So I think both can be problematic. I think during times of elections, that could be a lot of extra emails because the read receipt comes back to the sender. So that can fill up somebody's inbox pretty good if you're sending out a bunch of emails in one day. I think I do agree with the balance that it probably isn't indicative enough of whether a document was received. And none of the documents that we're talking about right now are things that trigger whether we can move forward with a case. It's just about us wanting to give notice to the parties in a sufficient amount of time so that they're not finding out about action that we have by reading about it in the news. We want, and we try our best efforts to make sure that we have good contact information ahead of time before we send out this information. So we're confident in the reliability of the information that we're the addresses that we're sending the information to. So to go back to your original question, we do not have a current policy. We're not opposed to it, but in balance, I think it's probably not necessary.
Mine is, I would take out F, and I would encourage folks to use read receipts as a policy. This is just one commissioner speaking, knowing that they can lack real probative or definitive value, but I would just, we don't have to overthink this here. I would take out F unless we've found that there's something useful to it. I find that it's a minor, but I may be missing I'm missing the depth of it.
I'm fine with removing. I would ask that if we start to experience issues with folks saying they're not receiving email notifications, that the commission, Chief Brereton, be briefed on that at a meeting. And so we can at that time decide whether, in light of that experience, whether we wanted to reconsider. Right. So,
Mr. Chief, the thing that I was trying to say when the sound cut out, just very briefly, I thought now probably 20 minutes ago that there was some discussion of kind of mandatory fields and forms versus the idea of a checklist. And I was trying to weigh in favor of something more like a checklist, because the mandatory fields and the forms can be really frustrating for people. But I also understand that's way outside of the scope of what we're doing. I just heard a mention in I do survey research for my job. So I perked up and wanted to just pipe in and say, let's not make things impossible to submit for a missing piece of information.
right. Thank you, Commissioner Wood. I think we landed in it's more like a checklist. Right. Good. All right. Any other questions or comments for staff? All right. We've called for public comment. At this time, I would then move adoption of the regulations item 13, with the understanding that paragraph F on page 7 be struck because it was inadvertently included. That's my motion. Do I have a second?
Second.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
Motion passes.
Right. Thank you. All right. So we'll now proceed to item 15. This is adoption of proposed regulation 18315 regarding referrals of commissioner-related complaints.
And Mr. Chair, for this conversation, I don't have a conflict, but just for extra clarity, I'm going to step out, and I will just ask that Ms. Linker or have them let me know. I'll be in the hallway for when the conversation is complete. Thank you.
Thank you, Commissioner Baker. All right, with respect to item 15, Mr. Bainbridge, you're presenting this, aren't you?
Back again, yeah.
Back again.
Dave Bainbridge, General Counsel, presenting item number 15. This is a proposed regulation that was first heard by the Commission in April. The purpose of this reg is pretty simple. It's to address the situation where a complaint is filed with the FPPC's Enforcement Division alleging that a sitting commissioner has violated the Political Reform Act. Obviously, commissioners are public officials and subject to the Act, and there's a possibility that they could be accused of having violated the Act. And as the main body that typically prosecutes violations of the Act, it is a possibility that occasionally we will get complaints alleging one of our own commissioners had violated the Act. So this regulation explicitly states something that is already an option for the Commission, which is the referral of a case to another body that has the authority to pursue legal action under the Act for violations of the Act. In this instance, what the regulation requires is that the Commission, if the Enforcement Division Chief receives a complaint alleging a sitting commissioner has violated the Act,
that it be referred for adjudication by the Attorney General's office. The reason the Attorney General's office is selected is because that's the office that has civil authority over alleged violations by commissioners or the commission. So the Act has already indicated that they think this is the appropriate person to adjudicate these issues. So what this regulation would do, it really does two things. One, it mandates that the referral be made. Currently, it's not mandated in law that it be referred to the Attorney General's office. And then the second part is, and this is the part that's been added since pre-notice. Initially at pre-notice, it was really just a very simple, any allegations of violations get referred to the AG's office. This now has a little bit more process, which was suggested by the commission at the pre-notice meeting of exactly sort of how the referral takes place. So a few items that have been added. If you look at they're kind of throughout, but one of the procedural requirements is that it must be referred within 2 days of receipt. That's business days. This came about at the direction of the commission to ensure that these are handled quickly and the matter is transferred from the commission almost as immediately as possible, and that it then is in the hands of the Attorney General's office so that it can make a determination quickly on what to do with the complaint. The other procedural part that was added was that the chair or vice chair would be made aware of the complaint so that there is some awareness on the part of the leadership of the commission. It'd be the chair unless the complaint happened to be against the chair, in which case the vice chair would be informed. The way it's written, it doesn't provide for anything other than them being informed that the complaint has been filed and subsequently referred to the Attorney General's office. And then it adds a process for upon referring the complaint, it provides a process for providing notice of the referral as well as a copy of the complaint to the commissioner who is accused of violating the Act, as well as to the complainant who has submitted the complaint. This mirrors closely how complaints in all other situations or sworn complaints are handled in terms of providing notice to the parties involved of what had happened. At pre-notice, the commission had suggested including language encouraging the Attorney General to follow FPPC timelines in pursuing cases to ensure that matters can be resolved in a timely manner. After looking at this closely, it's staff's recommendation that we don't need to add anything other than the 2 business day requirement to refer it, because the requirements in the regs and in the statute all relate to how quickly the commission processes complaints and makes decisions on complaints. In our mind, by transferring it to the AG's office, that's akin to making a decision on what's going to happen with a complaint. After a complaint has been either opened or into a case or closed, there's really no timeline. Specifically, once a case is opened, once a complaint is converted into a case, there's no timelines that follow that. It's just however long it takes to resolve the case. And because of that, we thought it would, by having the 2 days, we're covering our bases in terms of ensuring that at least at the complaint phase, it's handled as quickly as possible. Once it goes to the Attorney General's office, it's obviously out of the hands of the commission, which is the design of the reg to begin with. The Attorney General's office has been informed of the proposed regulation and had an opportunity to comment. We haven't received any feedback from them, which we assume that means they're okay with the way it's written. In conclusion, I think this reg is a simple and common sense way to maintain the integrity and the high ethical standards of the commission in these fairly rare circumstances where there are allegations against a sitting commissioner. Happy to answer any specific questions about the regulation at this time.
Thank you, Mr. Bainbridge. Just a point of clarification, the intent of this regulation seems pretty clear. It was corrected that if such a complaint against a sitting commissioner, we are immediately using ourselves and sending it out the door to the Attorney General. And implicit in that is that we will take no action to analyze, assess, evaluate, whatever words you want to use, anything about that complaint. We send it out the door. Is that your understanding of the spirit and the intent of this regulation?
Yes.
The second question I had is, it occurred to me a minute ago when we were talking with Mr. Cornwall about the new media policy for responding to requests for information. And so we have this regulation. If we adopt the current regulation we're discussing, that within 2 days, the Chief of Enforcement sends Commissioner out the door to the AG's office. The question is, what policy then exists with respect to commenting on that event? I would ordinarily think that we treat it the same way that we treat our policy with respect to pending enforcement matters, which is no comment on the specific facts, et cetera. That's under Regulation 18360. I just want to, it's not clear to me that we've addressed that specifically in the regulation, and so I wanted to raise that because I think our intent would be it is treated with equal parity, but I want to make sure that we've pinned that down. I don't know if we need a cross-reference to that in 1831.
Yeah, you're correct that it's not specifically called out in this in this regulation. I think that would be the analogous situation. The other option would be that it's a closed case, but it's obviously not closed because it's being investigated by another agency. So I think if we think that's necessary to spell out in the regulation, we could do that. I'd have to look at it and figure out exactly how or where. But I think it also could be stated on the record here that that's the intent in case there were questions about it.
Well, if that was your understanding going into this exercise, then I'm fine with making sure that we have it clear on the record. I just want to make sure that everybody is creating equal parity here. That was my only.
More of a technical question. At what stage, I think I'm pretty clear on this, but at what stage, Mr. Bainbridge, would the commissioner be informed that there's been a complaint filed?
They would be informed upon it being referred to the Attorney General's office.
Okay, that was my understanding. I just wanted to clarify that.
Commissioner Wood, any thoughts or comments on this?
No, I like it as it is.
All right, is there any public comment on item 50? Hearing and seeing none, I'd move adoption of item 15 as presented.
Second.
I can second.
Commissioner Wilson,
Aye.
Commissioner Wood,
Aye.
Chair Matich.
Aye.
The motion passes.
Excellent.
Clarification for the record, it was seconded by Commissioner Wood. So.
Sorry, I feel like I'm not pulling my load if I don't occasionally second some things, you know?
You're doing great. You're doing great. All right, moving right along, we will next take up item 16. This is our budget report, and with us is our Chief of Administration and Technology, Ms. Hahn. Good afternoon.
Good afternoon, Chair and Commissioner. I'm here to provide an update of the fiscal year 2022 and 23 Budget Act. I would like to submit the report as is, but I wanted to just mention that the budget came in line with similar to the governor's budget and the beginning of the year that I presented, so there's no changes.
Any questions for Ms. Hahn on the budget? Good. Anything? All right. Any public comment on item 16? Hearing and seeing none. Thank you, Ms. Hahn. Appreciate it. All right. We'll next move to item 17. It's our legislative update with our senior FPPC Legislative Counsel, Ms. Nakano. Good afternoon. Here, there's nothing going on with the legislature right now.
Good afternoon, Mr. Chair and Commissioners. Well, they are currently on summer recess, but staff is keeping busy in the meantime. They reconvene on August 1st. During this recess period, staff is working with legislative staff on developing final amendment language for various bills to iron out any lingering issues. Staff is also continuing to reach out to interested parties and to seek bipartisan support on commission-sponsored bills. Two commission-sponsored bills, SB 921 relating to the Data Act and SB 1483 relating to the Commission's new Political Reform Education Program, were held in the Senate Appropriations Committee and will not be moving forward this year. AB 775 by Assemblymember Berman, the two-year bill relating to automatic recurring contributions, will be amended in early August after the legislature reconvenes. These amendments include a language that would address some concerns that came up last year about whether the bill would interfere with organizations that collect contributions through things like membership dues. The amendments will also add Assemblymember Cunningham as a co-author, officially making the bill bipartisan. I'm working with Assemblymember Berman's staff, and I'm also conducting outreach to organizations that may be interested in supporting the bill. So far, the League of Women Voters of California and California Common Cause have submitted formal letters in support. I was asked at the Law and Policy Committee last week to look into whether the Republican caucus has any concerns about the bill, and as of now, I reached out to them, and as of now, I have not heard any. AB 1798 by Assemblymember Bryan, making a minor change to the ad disclosure rules, continues to move through the legislative process, and AB 2172 by Assemblymember Cervantes, relating to allowing filing by email with SOS instead of by paper, saw some minor amendments that were requested by the Secretary of State's office. The amendments provide that for a person who chooses to file by paper, that person would no longer be required to file 2 duplicate paper copies to the SOS, and would instead need to file only 1 paper copy. According to SOS, they simply have no need for the second paper copy. And I'll pause here for any questions about commission-sponsored bills.
In terms of, I don't have the exact bill number in front of me, it's in my notes. But first of all, thank you for your presentation, informative presentation. But, you know, the bill that the chair and vice chair is taking the lead on regarding recurring payments, you talked about, you know, some amendments that would be offered. My understanding, those amendments would not impact the original intent of the commission when they first proposed this legislation. But what's your take on that whole issue in terms of so-called clarifying amendments?
The author's office, we've been working closely to work on language that ensures that the original intent of the commission remains intact. And I think we're confident that's the case, and we're still getting at the kinds of committees that have been found to use this practice most often and in the most troubling ways.
Perfect. Thank you.
Mr. Chair, may I?
Yep.
In addition to the membership-related clarification, which we've talked before about in law and policy a couple times, can you say if there are any other provisions what are the other provisions that may currently be discussed, or is that the only one? For 775, excuse me.
The other major substantive change is to require committees that accept a contribution in violation of this new section to return that contribution within a certain amount of time. So currently the section doesn't require a return of improperly collected contributions. This just clarifies if they collected improperly, they need to give it back to the contributor.
Okay, and that's certainly, I think, well within the intent of what we were going for sure, is that there has to be a refund. Well, I want to say excellent work on reaching out to organizations to stand with us on this very important bill, and for the work that's been done to make it a bipartisan bill. I think that's extremely important for all that we do, but certainly something like this. And I guess I reaffirm that you do an excellent job of keeping us informed should any more substantive amendments be requested or required before our next commission meeting. I know we have law and policy coming up, but we'll be eager to hear about that because things move so quickly once August 1st comes when they're back in town. So thank you.
And there is one more change that, as I'm reviewing the language in my head, I'm recalling. There was a request to clarify what counts as a violation. So I think there will be some clarifying language to state exactly what actions count as a violation under that section.
Can you say anything more about that, or where that request or feedback either came from and where you're going with it?
I believe the feedback came from the elections committees, just wanting to make sure that it's clear exactly what types of actions will count, whether it's I think it's making a distinction between the initial solicitation and acceptance of a contribution and then subsequent acceptance of contributions, and whether each one is a violation or whether those, or exactly how that's going to work. So from what I understand, and I think the language is somewhat still in flux at the moment, but the main idea is that at least the first one will count as a violation, and then how we're treating subsequent violations, I think, is up to, we're still determining.
Okay, so the first solicitation, for example, would be a violation that could be up to $5,000 fine. Trying to play this out in something concrete, mostly for colleagues. And then if the repeated recurring contributions that the person did not presumably consent to continue, say every month, the discussion that you're having with the elections committee is whether those will count as $5,000 separate individual accounts, or if they'll somehow be treated differently. Maybe other options that I'm sure you're looking at, perhaps are combined, perhaps there's a formula for what a fine would be for them. That's the conversation that you're having. I just want to make,
yes,
our colleagues may not hear about this again until the legislature has made its decisions about it, but I think that's what you're referring to. Is that
yes,
right?
I think that's an accurate representation.
Commissioner Wood?
So, Ms. Nakano, thank you again for your presentation and all your hard work. I can't figure out how to find this, and I just wonder if you could catch us up on Senate Bill 921. I know it was held in committee. Was there any conversation before it was held in committee, or was it held just as a part of, a big vote with a bunch of them? I'm just curious as to what the objections were for it, because it's something I care deeply about. Thanks.
Thank you for the question. So the bill was last in the Appropriations Committee, and unfortunately, what goes on in that process is a little murky. We don't know what conversations happened. It died on suspense, which means that while they were going over the file of all the bills that they were considering, the bill was just not passed. There was no discussion. So we really don't have an idea of exactly the conversations that occurred in that committee.
Clarification,
Okay.
this is the, can you remind?
The digital ads.
The Data Act bill.
Yeah, got it. Thank you. So,
Any further questions or comments from Ms. Nakano on the first portion of her presentation? All right, continue on, Ms. Nakano.
Okay, I'm moving on now to other commission-related bills. Since our last update, all of the commission-related bills, or remaining commission-related bills rather, continue to move through the legislative process, except for AB 1819 by Assemblymember Lee. This related to limiting contributions from foreign influenced business entities. This bill as well was held in the Senate Appropriations Committee. AB 1783 by Assemblymember Levine relating to expanding lobbying under the Act to include attempts to influence decisions to approve certain mergers or acquisitions was amended to change its method of approval. The bill was previously written to require voter approval, which would mean the bill would only need a majority vote of the legislature. The bill was amended to instead require a 2/3 vote of both houses and no longer needs voter approval under the PRA. There's a new bill amending the PRA, SB 794 by Senator Glazer. The bill was amended to delete its former contents and now would allow a committee to knowingly accept a contribution that is over the applicable limit in the PRA as long as the committee returns the excess portion within 72 hours and does not make use of the contribution prior to returning the excess. The bill would cap the amount of the excess contribution that may be initially accepted to contributions of no more than twice the applicable limit. According to the author, the purpose of the bill is to allow committees to essentially provide change for contributions that are over the limit instead of having to return the whole check. The bill also codifies an existing regulation that allows return of over-the-limit contributions where there is no actual knowledge that the contribution was over the limit. There were some questions that came up about the bill in the Law and Policy Committee last week that I will attempt to answer now. One question related to whether the Act, in any other circumstances, allows a person to knowingly violate the Act and then cure the violation. One somewhat similar but not completely identical example relates to the gift rules. The Act prohibits elected officers and certain other individuals from accepting a gift over the limit from a single source in a calendar year. However, regulations provide that a gift is not considered accepted or received if it is returned or donated or the donor is reimbursed within 30 days of receipt of the gift, and knowing or not knowing is not an element of the exception. So under these rules, paying down the gift, returning it, or donating it within 30 days negates the initial acceptance of the gift over the limit. And not exactly the same kind of example, but a similar one. There's another question about whether this bill could open the door for potential misconduct. There's a relevant concern relating to the idea of puffing or claiming that one's contributions are higher than they really are based on the initial receipt of excess contributions. And this is something that the Commission expressed some concern about in early 2020 when there was discussion about a related regulation. Generally, I think capping the amount over the limit that can be accepted to twice the applicable limit helps to somewhat alleviate concerns about potential misconduct, including puffing, but there is still a potential for that to occur. There's also a question about what it means for an excess contribution to be deposited with actual knowledge that it's over the limit. The bill does not currently define the term. It's not otherwise defined in the Act or regulations, so it would be up to the Commission to interpret that. One interpretation is actual knowledge, meaning facially over the limit. And that's, I think, a fair interpretation. And if this bill passes, staff may wish to revisit the issue, potentially in regulation. There's also a question about the impetus for the bill. I got in touch with the author's office, and there were no specific examples or situations provided by staff on the bill. The purpose of the bill is simply to allow committees to return the excess portion of a contribution so that they are not required to return the whole physical check. Last, there are questions about whether federal law or other states allow return of excess contributions with actual knowledge or otherwise. Federal law allows a committee to return, redesignate, or reattribute a contribution that is over the limit within 60 days. Based on my research, I'm unaware of any knowledge limitations, so I believe that at the federal level, a committee would be allowed to initially accept a contribution over the limit, even with knowledge that it's over the limit. I also looked at other states as well as local jurisdictions, and I had some help from Commission Counsel Caitlin Green, who had previously done some research in this area. I looked at several other jurisdictions that have relevant requirements relating to acceptance and return of excess contributions, and the most stringent requirement came from San Francisco, which has no grace period and requires that the excess contribution be forfeited to the city if deposited. Some of the jurisdictions I looked at do have grace periods, and those include San Diego, Los Angeles, Colorado, Arizona, Connecticut, and Hawaii, and their grace periods generally range from between 10 and 75 days to return the excess portion of the contribution. Of those state and local jurisdictions with grace periods, some did reference some kind of intent or knowledge conditions. Los Angeles, for example, allows staff discretion to not allow for the grace period if there is evidence of intentional conduct. And Arizona prohibits knowingly receiving a contribution over the limit. Other jurisdictions had no apparent knowledge conditions or were unclear. And I'll pause here for any questions or discussion from the Commission on this bill.
Any questions for Ms. Nakano on this?
On the, I'm very grateful. We did have a lot of questions in law and policy on this one. It's come somewhat late in the legislative process. It's a gut and amend. And one of the big ones was what are they really trying to get at? Because the terminology that they like to make change is a little difficult to kind of visualize. And so I try to imagine a situation where I guess a campaign's receiving checks perhaps at an event or otherwise, and it's right now, am I correct that if a check were handed to, say, a campaign staffer or the candidate, and they see it is over what they know this person is either already given as the maximum or otherwise, they have to give it back, the whole check. And then I guess they have to hope that they chase down whatever allowed amount they're to give. I'm not trying to negotiate for the author, but I'm trying to anticipate a situation that it's responding to. So is it correct that right now the check has to be returned immediately before it's even deposited, before they can do anything with it, the whole check? That's the situation right now under the laws. The whole thing has to be given back, and
Yes,
it's immediate. They don't have
yeah.
There's no grace period and under our current regulations. Okay. I was concerned about the puffing because, campaigns do try to get all they can in before a filing deadline so they can use that to show they get a lot of support and they're raising more than the other person and otherwise. And I still have that concern. I think narrowing it down to 3 days helpful. I mean, it's not, I heard 60 days or 75 for some of these. But why the double amount? Is that anticipating that you can give more than a double maximum contribution? You mentioned that might limit the puffing problem, is if you can have a cap on how much can be over the amount. Where did the double come from?
That suggestion was made by the committee. There was some concern that if there was no limit, that a committee could initially accept essentially an unlimited amount of a contribution. It could be millions of dollars. And in that instance, I think the puffing concern is elevated since that's a much higher amount that they could then potentially advertise that they have.
It also, if I can just hop in, it sort of makes sense if you're thinking of it in terms of you get a check for, let's say, $8,000 and the max you could receive for the primary is $4. Under the bill, you simply accept the $4 goes to the primary, and the other $4 gets designated to the general, right? So having the max amount at twice the limit, I think is consistent with that scenario.
Well, thank you. I struggled with both the possibility for manipulation and the concept of knowingly accepting a contribution over what is allowed, and trying to understand why there's an effort here to try to change that and make it possible. Welcome colleagues' thoughts, or maybe they don't. We can move along.
Well, on that point, I guess I'll repeat what I said at Law and Policy, which is I think framing the conversation as it being allowing a knowing acceptance of something, I think is, to my mind, that's not the right way of framing it. We use that terminology, and I think the reason that's even in the bill is because of our regulation, which refers to the knowing acceptance of a contribution. Right? And what we actually meant, I think, in the regulation when we used that term was a facially over the limit check. And the real question under the regulation is the treatment of a facially over the limit check versus a situation in which through a series of contributions you find yourself with an aggregate amount that exceeds the limit, and what do you do? So I think the reason that knowing language is in there is just simply because we use that in the regulation, but the only reason we use it in the regulation was to differentiate two different situations. And what I think we really meant was facially over the limit versus an aggregate situation. And when you look at it from that perspective, it seems to me that the purpose of the bill is to better align the treatment of a situation in which a committee receives a facially over the limit check with how the federal rules apply in those circumstances. When you look at it that way, it becomes much more of a kind of a logistics thing than it does an effort to subvert the rules in some way. That's just kind of how I'm seeing it. Other commissioners have any comments? I don't know. What else do you have for us?
Yeah, move on to the next bill, SB 1352. This is by Senator Allen. This bill also saw major substantive amendments. The bill previously would have required contributions of $2,500 or more to be reported within 5 days. if the contributions were received before the 90-day pre-election period. The bill was amended to delete the prior provisions and instead require candidates and committees to file a third pre-election statement no later than 70 days before the election. Currently, there are 2 pre-election statements filed for the periods ending 45 days before the election and 17 days before the election. At the Law and Policy meeting, there was a request for a visual or more clear explanation, a layman's explanation of how the bill changes the reporting requirements that affect disclosure. So I have a brief PowerPoint that I will share now. Yes, there's more than this. Okay. As I mentioned, under the current filing schedule, there are 2 pre-election statements, and under SB 1352, there would be 3 pre-election statements, but covering the same period. And I'll go more into how that works and how that interacts with the other filing requirements. Thanks to Chloe Hackert for the visual on this slide and for sharing her expertise on the filing schedule and how the bill changes existing law. Here's a visual representation of the filing schedule over the course of a year using the upcoming November 8th, 2022 election as an example, and I'll briefly go over the components of this. There are 2 general types of statements and reports, statements that are filed on regular dates or intervals depending on the date of the election, and those include semi-annual statements and the 2 pre-election statements. And there are activity-based reports that are triggered when a committee receives threshold levels of contributions. For the November 8th election this year, before August 10th, contributions of $5,000 or more must be reported within 10 days, and from August 10th up to the election, that's the 90-day election cycle, contributions of $1,000 or more must be reported within 24 hours. This slide shows the current filing schedule for pre-election statements versus the filing schedule under SB 1352. Under current law, as you can see on the top, there are 2 required pre-election statements. The first statement covers the period from July 1st to September 24th and is due on September 29th. And the second statement covers September 25th to October 22nd. Under SB 1352, there would be 3 pre-election statements covering the same period. The practical effect of the bill is that for the November election, the reportable activity occurring in July and August would now be reported about 1 month earlier compared to existing law. So the activity for those months would be reported on August 30th in the new first pre-election statement instead of on September 29th. And this is consistent with the purpose of the bill as expressed by the author, which is to get more timely disclosure earlier in the year. And I'll pause here for any questions.
The author's office provided any input or studies or evidence of when voters tend to start paying attention to things ahead of an election? Because I share the goal of getting things out fashion for voters. I guess sort of anecdotally, my sense had always been that voters pay more attention closer to the election. And if I'm understanding you right, under this proposal, information from July and August is actually being reported at the end of August as opposed to which is closer to the election, which is when I would think people would pay more attention to the November election. But do you have any thoughts on that?
Based on what I've heard from the author's office, I'm not aware that they have any studies about voter engagement or how interested they are in contributions that far from an election. So, no, I'm not aware of any information like that.
Any other questions for Ms. Nicole?
I mean, I could just pipe up and... Sorry, can you hear me?
Yes.
Okay, sorry, I didn't ask for permission. I would just pipe up to say that if they do start paying attention in September, then under the current system, there's not really any filing that happens before the end of September. And so this would allow them to have the information in September in a way that they currently don't. So I mean, I know there's more of a compliance burden here if we were to make the change, but it does provide, I mean, having that information a month early, especially given that the ballots get mailed out at some point pretty early, right? So you'd be able to see kind of a level as of September and maybe also a trend by the end of September for the October report. So that's kind of a nice feature here when we think about information, getting information to the voters.
Thank you, Commissioner Wood. Any other comments from Ms. Nakano? Thank you, Ms. Nakano. Anything further on your report?
Two more quick updates about some remaining bills. SB 1360 by Senator Umberg relating to advertisement disclosures was amended with relatively minor changes, making some changes to different disclosure text and appearance requirements. SB 1439 by Senator Glazer relating to agency proceedings and the disqualification requirements was also amended. Most notably, the bill strikes the requirement that was added by an earlier version of the bill that would have required a party to submit a statement to the agency prior to the proceeding disclosing certain contributions. That concludes my update, but I'm happy to answer any questions.
Thank you, Mr. Kano. By the way, thank you again for the visual on 1352. That was really helpful for just kind of understanding how it would be different from existing law. With respect to our work and for bills that you've presented to us that we may not have taken a position on, based on the calendar that's before us, it looks like the last day to amend on the floor is August 25th. I think our meeting is a week before that. So is it your sense that if this commission wants to weigh in one way or the other on these bills, the last opportunity for us to do it really is at the August meeting?
Potentially, if the bill was moved sooner, that opportunity might be lost, but that would be the latest at the August meeting.
Okay. I just wanted to point that out to our colleagues that there are particular items that we either have not taken a position on or we've taken a position on and we want to reconsider it. August is the time that we need to finalize those decisions. In fact, definitely see you back before us in August, Ms. Nakano. All right, Commissioner Baker, any?
Thank you. No, it was just on, yes, there is something else. It was on AB 975 by Assemblymember Rivas. And this is one that, and you may have to, I may be confusing the law and policy discussion with full commission discussion, but this is one that has a provision that informally, at least I, and I think others have expressed a support for the first part. It's on page 4 of the memo that you prepared. But there's another provision that we've discussed some concerns or reservations about. Now, I will confess, I don't recall if this is the one where we were deciding between a support if amended as opposed to oppose if amended position, or if we've provided any other information. I see here it's no position. But it is a concern to me, the provision of the bill that I think makes it less transparent to the public about gift reporting. And can you give us any more information than what's in your memo on where things are at with that? And have we had any conversations further about support if amended, oppose if amended, or did we just decide not to take any position at all and stay off? Do we still want to do that? Because it is a change to transparency that is concerning to me.
This bill we did not take, the commission did not take any position on. I think the one that you are alluding to that we took a kind of half and half position on was 1360. That was relating to the advertisement disclosures,
yep.
Which include both elections code and PRA
That's right.
sections.
Thank you.
This one passed in the elections committee. I don't think it will go through the appropriations committee. I believe all the costs are minor. So its next step would be a vote on the Senate floor.
Okay. And yes, please.
When we last spoke about that bill, part of the reason we took no position at the time was because we had, I think, asked you to go back to the author and explore some other approaches to the second half of the bill with respect to gifts. And so I don't know if you can update us on the prospects there, but if you're continuing to have conversations with them about the concerns we previously raised, it would seem like we would want to consider changing our position at the August meeting after we have the benefit of your report back on those discussions. But do you have anything that you could share today, I suppose?
I did reach out to the author's office. I think there was a suggested change that came from you, Mr. Chair, and I proposed that change. They were not open to changing the bill, and I think are hoping to keep it as is. I don't know if they're open to any changes at this point.
Appreciate that. Just for clarification, I want to make sure that I have the right bill. This, Mr. Connell, this is a bill regarding filing requirements and gifts?
Yes.
Okay. Just for the benefit of the public, you could just like a one-sentence description of what this bill does.
Yes,
because your analysis is very detailed, but I just think it'd be helpful for the public.
Certainly. The bill has essentially two parts. The first part relates to statements of economic interest. It requires certain public officials to file them electronically with the FPPC. The second part relates to the time in which an official has to donate, return, or make reimbursement for a gift. So under the current rules, they have 30 days from receipt of the gift to decide what they want to do with it. Under the bill, they would now have 30 days from the end of the calendar quarter in which it was received. So it could potentially expand that amount of time quite a bit.
Any other questions or comments for Mr. Kano?
I just would point out that this could be voted on before we have our next meeting. And because if it's ready to go up to the Senate, it might be one of the ones that clears the deck before the actual deadline. And I don't think we're going to see any further changes. I think if it's definitely in our wheelhouse, and I do think there is a lack of transparency. Perhaps the author is trying to make it easier to comply with the rules, but I think it's a significant change from 30 days to 30 days after the quarter at which the gift is provided, which for election purposes can be quite a bit after an election, primary or general or otherwise, and have concerns. For my part, I'm not putting this in the form of a motion because I do welcome colleagues' thoughts on it. I would take an official position if we support the first part, think it's great. I do think this would be wonderful, but that we regretfully oppose the second part for not being as transparent for the public, particularly in important decision-making times, as the PRA would probably want to remain. And that's what I would do. I'm not putting it in the form of a motion right now because I want to welcome thoughts from colleagues. I know we're getting into well past the caloric intake of most people, but I don't know that we're going to have another chance to weigh in on it.
My thought is, absent Ms. Nakano telling us that there's some imminent action on this, that we take up this bill along with all the others in August for a position. That's my own personal view, but if others disagree, we can certainly put it in the form of a motion today.
Understood. I think I can do that, and certainly law and policy may come up before then, and that may be the opportunity to, that's certainly even the week before. So my fingers will be crossed that it doesn't, and that maybe magically some changes will happen. Thank you.
It did actually remind me, though, this discussion. I had one other question for you, Mr. Kano. On 975, my understanding of the Political Reform Act is that the legislature has the ability to amend the act consistent with its purposes and intents with a 2/3 vote. I share my colleagues' concern that the second half of this bill, in my mind at least, doesn't advance the purposes and intent of the bill. Has there been any discussion about whether this bill could lawfully be enacted by the legislature even with a 2/3 vote when it contains that provision?
From my recollection, I don't recall that discussion happened in either elections committee. So from my understanding, no, that has not happened.
I was just curious if anybody had brought that up. Okay. Any other comments from Ms. Nakano before we?
I don't have a question for Ms. Nakano. Are y'all getting that feedback? Okay.
All right, try it again.
I don't, sorry,
We found
I
the
don't have
culprit, but we're not
questions.
saying who.
Right, exactly. I don't have questions for Ms. Nakano. I just, I guess, you know, I haven't been on the commission long, so if it's a little aggressive to go ahead and take an opposed stance for the second half now, then I will follow the lead. But I just wanted to say that I actually do oppose the second half. And for the reasons Commissioner Baker brought up, I think it could bring up, you know, as much as a 4-month lag between the receipt of a gift and the time that the public finds out about it. And so I'm willing to tread carefully if that's what you want, but if there were enough votes here, then I would be willing to go along with opposing it, the second half of it now.
I'll add before you make a decision, there are some challenges with opposing only a portion of a bill. As you recall, with 1360, I only provided a verbal testimony about our position. The legislature has a online position letter portal, and you're able to click whether you support, oppose, support if amended, oppose unless amended. There's not a split position, so it could be challenging to effectively communicate that to the legislature given the tools that we have.
Well, and I think that's right. So it's like it's really either support if amended or oppose. Those are our two options today based on what folks have said. And my thought is, I think we've made our sentiment very clear, like in several meetings, about how we feel about the second part. And I just want to make sure that there's ample opportunity if they want to amend to avoid that opposed position ultimately, that we afford that to the legislature. I just think wait until August makes sense.
If I may, Mr. Chair, I'll say this. From what I'm hearing, the author has, I think, politely communicated to us they do not have an interest in changing it. And so I don't know, to be honest, what would change between now and even law and policy, or when it could come up on the floor. So, if we really don't support this part of the legislation and something that's a core part of what we have oversight over, I don't see a need to wait, and I personally wouldn't be constrained by the forms. I don't, just having our own position letter out there, members will get an analysis that'll list who opposes it, and couldn't it say support in part, oppose in part when they list us? I don't know, but I'd at least like our statement to be, we support this other part, which we think is great, but this one we just can't get behind, and we would encourage you to omit from the bill, and get that out there for our own part. I don't know that it'll have any effect, but I'm talking myself out of it from a few minutes ago. I don't know that waiting's going to do anything. We're in the last 30 days of legislation, and I think what I've heard from Ms. Nakano is that the author has declined the opportunity to make any further changes to address our concerns. That's what I'm hearing. But Commissioner Wilson, I don't want to.
I think Commissioner Baker and Commissioner Wood and Chair Madich made some good points, but it's not the author's. The author doesn't have this, the sole authority to determine what the final version of the bill will be. The author might accept some amendments that are recommended as this bill moves to the final stages of the process. So, I'm inclined to agree with the chair that probably reserve any final recommendations until August.
All right. Anything further for Ms. Nakano?
Nothing further for me, thank you.
All right, thank you, everyone. Go ahead and proceed to item 18 then, our executive staff reports. Back, Chief Brereton. Before it was good morning, and now it's good afternoon, Chief Brereton.
All right, good afternoon. So I do have a few updates that I wanted to share that are not included in the report directly. So as you all know, we had the primary election in June. So I wanted to share some of our numbers with you from that period of time. We received a total of 639 complaints and referrals during the 90-day period preceding the election. About 140-something were related to SEI, Statements of Economic Interest referrals. So about 480 or so were related to campaign referrals or complaints that we received. So we did a lot of review during that 90-day period. Included in that was our proactive pre-election outreach. To remind you about that program, our intake staff reaches out to filing officers in the state and asks them if they want to participate. And what that means is that they would send us referrals within a couple days of the deadlines for the pre-election campaign statements for folks who have not filed. And then our intake staff reaches out to try to get compliance. If they cannot achieve compliance at the intake level, then those cases get referred, or those matters get referred to attorneys in enforcement, and attorneys try to reach out and get compliance. So for the first pre-election statement, we had 31 referrals, and all of them complied at intake except for one. That was sent to an attorney, and then that person complied. So we had 100% compliance for the first pre-election statement. We had 36 referrals for the second pre-election statement, and all complied except for 4. So those 4 were sent to attorneys, and we achieved 100% compliance before the election. Also, we had our AdWatch program in place. We received 47 submissions in the 90-day period before the primary election. 28 of those were related to non-electronic advertisements. 19 were electronic, and we did not receive any for public mailers. And just to give you some context, the March 2020 primary election, we received 42 submissions during the 90-day period preceding the election, so we had a slight uptick this year. The other thing that I wanted to mention is that, as you can see in our report, like, we do have older cases still from 2016 and 2017. Our goal this year is to have all of the remaining 2016 and 2017 cases resolved or in a position of administrative process by the end of the year. If you have any questions about anything else in my report, I am happy to answer them.
Any questions for Chief Brereton on her report? Good. Right. Great job, Chief Brereton. Thank you very much.
Thank you.
Move next to the Audits and Assistance Division report. Steve Shaw. Steve Shaw.
Good afternoon, Chair and Commissioners. My report is as submitted, but I'll be happy to answer any questions you may have.
Any questions for Chief Shaw? Thank you for your report.
Thank you.
Next to the Legal Division report, Mr. Bainbridge.
Back again, I'll try to be brief. Just wanted to point out on page 12 that we have some new and updated educational resources. We've updated and expanded the page on campaign advertisements by government agencies. So that page was there before, but we've expanded it and provided lists of cases in that area as well as advice letters. So I would encourage those city attorneys that are listening to maybe go check that out. There's some more resources there for them to to understand how the commission has interpreted that law. We also created our education division, a Form 800 series search page on our transparency portal. There's a handful of forms in the 800 series. They're all now in one place if you want to go search for them. The most prominent one being the Behested payment reports. Just trying to make those easier to find for people since they're required to be put on our website. And then last of all, the Political Reform Education Program, also known as PREP, the website for that is up. And next month we plan to come back with a presentation from Chloe Hackard on how that's going. We got it up and running as to the SEI program. I believe so far we've had one person complete the course. So we're getting feedback from that, and we'll have a better update as to how that's going next month. A couple more things to point out quickly. On page 13, we had a couple more SEI exemption requests that were granted over the past couple months, both involving law firm clients. One a candidate for state assembly and the other a San Diego County Superior Court judge. So just to remind those interested that this is a regulation that allows for someone not to provide sources of income on their SEI if the disclosure of that information is prohibited by some other law. So in these cases, we determined disclosing these clients would violate attorney-client privilege, so they were not required to disclose the name of the individual clients on their SEI.
Again, just to clarify that, though, it's not a sort of writ large exception for all law firm clients. In each of these cases, the folks who are applying for these exemptions, specific reasons why specific clients should be exempt from disclosure.
That's correct. It's not in and of itself the representation that excludes it. Often it's a matter of public record who people's clients are because they're represented in court, so those certainly aren't excluded. It's particularly situations where the fact that someone is represented at all could somehow cause them some sort of legal liability is the typical situation where attorney-client would prevent disclosure of the names of clients. And then lastly, kind of tangentially related, potentially adding to the potential upcoming regulations, I guess it was 2 months ago now, the commission, we had seen an enforcement case where we had a treasurer who was a minor. And the question came up, is that okay under the Act? And if it is, should it be, and can we take regulatory action to prohibit that? There's nothing expressed in the Act about the qualifications for a committee treasurer. So technically there's nothing prohibiting a minor from being a treasurer. That being the case, we looked at other areas of the law and did some research, and the capacity of minors is pretty limited for sort of the common sense reason of protecting the minors. They may not have the ability to understand financial transactions, contractual agreements, the wrongfulness of their actions. Essentially just their frontal lobe is not developed, so the law treats them differently in many different ways. And the Act requires that treasurers verify transactions and do those sorts of acts that the law in other places has sort of said minors are not capable of doing this on a way that can be legally enforced. So our conclusion is that it would be consistent with the Act to have a regulation that prohibited or that required a treasurer to be 18 years or older. So the question then, the commission had suggested maybe they would want to do a regulation on that. We think that's appropriate for a regulation. So it's just a question of timing when you'd like to do that, if we'd like to do it as quickly as possible, if we want to put it on next year's reg calendar. It's a fairly simple regulation to draft from as far as we can tell. We've done some initial work on it. So I'll leave it up to the commission whether we'll be adding that now or just putting it on the list for things next year.
That's something you're asking us action on in this moment, or should we wait till item 9?
I think we could do it either way. I bring it up because we do have potential upcoming regulations in our legal division report. So
it's okay that we talk about it now in the context of this item, Mr. Bainbridge. Then I'm happy to give my say, which is I would recommend that the commission direct staff to bring the regulation to us as soon as feasibly can. If it's easy to draft and you can bring it back in a month or two, I would prefer that. Colleagues agree with that.
Agreed.
Commissioner Wood, do you have any objection to that?
Oh, I mean, not really, but I wonder if we would want to make it effective after this election or something. I just worry about kind of mom and pop campaigns that would be scrambling for a new treasurer, but maybe I'm telling myself stories that aren't really out there yet. And maybe if we really think they shouldn't be treasurers, then, you know, I just don't want to have somebody have an enforcement action against them right away or something because of this. Sorry, that was so casual. I really.
I hear what you're saying. Mr. Bainbridge can correct me if I'm wrong, but even in the best case scenario where they brought us language next month, that would be pre-notice, and then we wouldn't have adoption until October, and then it wouldn't be effective until 60 days after that, which would be after the election.
Okay.
So I think we're too late to make people concerned about their kids being their treasurers for this election cycle.
Perfect. Bring it along. I'm ready.
Else, Mr. Bainbridge?
That'll do it.
I just have one real quick technical question. I think it was answered at a prior meeting. Have we ever, based on your experience, and I would also direct this question to Executive Director West, have we ever had another situation where a minor was a treasurer that you can recall?
I don't recall one.
Okay. Just curious. Thank you.
Right. Last but not least, Executive Director West. I know we had talked about doing, Ms. Hahn, I didn't mean to skip you. I know you're next, but as you're getting set, Executive Director West, I know we had talked about having Mr. Waringa do a presentation today of updating us on the success of our pre-election outreach program before the primary election. I'm wondering if maybe we can put that over till next month, given the late hour, and wrap it into, this is what we did for the primary, this is what we're going to do for the general, and kind of do them at the same time. Okay, all right. All right, Ms. Hahn. That's right, and we'll provide lunch next time. All right, Ms. Hahn, you're up.
Good afternoon, Chair and Commission. I would like to submit my report as is, and I'm here to answer any question that you may have.
Any questions or comments for Ms. Hahn? Appreciate it. And now, last but not least, Ms. West.
Hello. In the executive reports with bright, cheery news, we have with us today Ann Zhao, who is in the back, if she wants to stand up, although Commissioner Wood won't be able to see her, but she's our APAPA intern, and she's been helping us out. We're trying to update some of the reports that we've done in the past. So she's gotten the pleasure of receiving a download of information from Secretary of State's office and helping Sasha Linker go through it to make sense of it in order for us to produce the wonderful reports that we do. So she's been a great help, and we want to welcome her to the team.
Welcome, Ann. Thank you for joining us. Further, Ms. West?
I'd just say that APAPA is a Asian American Pacific Islander Public Affairs Association. You said APAPA intern, and I thought I would just throw in a little bit of extra information, so thank you.
Thank you. Thanks for that.
I hope that's right. I don't know too much.
All right. Any public comment on item 18? None. Our final item, item 19. This is future agenda items. I know just a moment ago we directed General Counsel Bainbridge to bring back a future regulation on minors as treasurers, prohibiting that. Do commissioners have other items they wish to add to future agendas?
Just from our discussion earlier this morning and the enforcement calendar, and I know our team works very hard, so I will be very deferential to what is a time frame that is reasonable that allows the work to continue, knowing I think we also have a annual report in December if that's the case. But I think it'd be helpful to just get a better understanding of our own internal mechanisms for tracking statutes of limitations, and it may be these are extremely rare blips, but it's good, given that it's come up at a couple of meetings now, to have that as publicly discussed. And then what I would also just add, and this definitely can be, I would suggest, part of the December annual report, if that timeframe is reasonable. The mention today, you know, that and I think it was mentioned at the last report, COVID has had an effect. I'd love to, you know, all businesses, all entities are really dealing with that. And if there's any, helping put some more information about that to us and any recommendations, is there anything we need to do to improve it or adapt so that our team, and I'm sure it doesn't just affect the enforcement team, I'm sure it affects everyone. It's just that our hardworking team in enforcement, you know, do have a statute on them, a statute of limitations and other constraints. And I think it's valuable for us to have a better understanding of what that is and what it might be doing to our function in that regard. And if there's any recommendations or changes that have been made, since it's also come up at a couple of discussions of timeframes. So that would be it. And neither of those, I think, are like immediate, perhaps in December, if not sooner.
All right. The first portion, let's go ahead and schedule that for December and include that as part of the enforcement recap in December. As to any particular things we've done in response to COVID, I think Executive Director West can brief us, if not next month, maybe in the next couple months, on certain things, change works. Makes sense for you to brief us on those changes.
Yeah, and I guess for my part, that just came up in the context of how it's affecting our, what obstacles it's putting to our enforcement team. So I would welcome that if the timing works out. Thank you.
Any other ideas for future agenda items? Wood, anything? All right, with that, let's, do I have a motion to adjourn?
Move to adjourn.
Second, Ms. Linker.
Commissioner Baker?
Aye.
Commissioner Wilson?
Aye.
Commissioner Wood?
Aye.
Chair Matich?
Aye.
The motion passes.
All right, thank you, everyone. Take care, and we'll see you next month.